We're going to have, let me start by the panel. I hope you are aware of the panel members. I'm going to ask you to switch on your mic.
Good afternoon to the panel. Good afternoon, Minister.
Good afternoon, Advocate Johnson. I'm going to, the first, how we do the interview is the questionnaire that we send you and you completed. We'll take you through. We allowing both the panel and the public to get to know you. After that, there will be questions from panel members. And then I must check who's taking you through the public comments. Okay, Mr. Mutloung will take you through, as the lead person from our side, all the comments that we've received. We've sent them to you. I think you got the highest comments.
I have, and not positive comments, but I do accept the comments, and I know we'll deal with them as we go through the process.
We will deal with them at the end, so you'll take you through so that you go on record responded. But we have also received your response in many of them. I'm going through that. In terms of your response, so we'll deal with that. You don't have to pressurize yourself in between to answer them. We'll give an opportunity just to go through what has been asked, and then you can deal with it. As we go through, Section 1 deals with your personal information.
Correct.
In terms of, you don't have to switch it off. Did you get the copy?
Not yet, Minister.
Not yet, or they're still, okay, let me wait a bit so that you have it in front of you. Oh, okay. Prof says there are no commercial breaks, unfortunately for me.
Thank you, Minister. I do have a copy.
Okay. Section 1 deals with your particulars. I'm not going to read them out, but move immediately in terms of your qualification. So would you take the panel through how these qualifications are relevant as you have them to the position of being a National Director of Public Prosecution?
Thank you, Minister and panel.
Let's ask them to move your mic closer. Move it closer. I don't know. They seem to have moved it a bit. The other candidates, we could hear them clearly.
Am I more audible?
Yes, perfect.
Thank you. Minister and panel, I studied for a B.Juris degree, and many, many moons ago when I initially enrolled for that degree, back at the time at the University of Durban, Westville as it was, that was the bespoke degree for prosecutors. Ordinarily, those who wanted to go into the profession as attorneys would do the B.Proc. I had always wanted to be a prosecutor. I then studied for an LLB degree. And then when I joined the Directorate Special Operations, colloquially the Scorpions, I realized that having investigators and prosecutors under one roof meant that I needed something more than just those two qualifications. And I then enrolled for a diploma in criminal justice and forensic auditing at the University of Johannesburg. And what these degrees do is they have given me a different approach to how I go about looking at crime, looking at the criminality, looking at evidence, and how to assess and judge, both in terms of evidence and the law. It has held me in good stead in terms of being able to deal with a varied type, as the panel and Minister would see from my legal background. It has helped me to deal with a whole host of matters. So in terms of being a national director, it gives me a strong legal background, a strong legal framework. What it has done is, having put me in the prosecution service, having exposed me to the kinds of work I've then had to do, the managerial roles that I've had to play, that then says, let us look at her. Should she then be considered as an NDPP? It is not foregone conclusions that these legal requirements actually put you in that position. It is the experience that has allowed me to be considered.
Let's move to that area then that you talked about the experience. Mic is off, sorry. Let's move to that area of your experience, and I'll just go through as you have summarized it. 96 until 98, a prosecutor.
Correct.
98 to 2009, state advocate.
Correct. In 1998, yes, till
1998.
2004 April was a senior state advocate.
Okay, yeah, we'll come to that. Because I'm looking at it, perhaps maybe you'll have to explain.
Sure.
Because I'm noticing that you've got state advocate and then you've got senior state advocate, and they are overlapping. June 1998 until November 2009. And then you've got senior state advocate, December 1999 to March 2004. Would you explain that one? Because there's an overlap there.
Unless that...
Just under 6.
My apologies, Minister. That would be a typo.
Okay.
The state advocate is from 1 June 1998 to 30 November of 1999.
Of 1999, okay.
1999.
No, it's correct.
Then the senior state advocate from 1 December 1999 till 31 March 2004.
Okay, so that has been corrected. That's why we want to go through properly so that we have
Understood.
the record. And then you've got under the DSO, senior DDPP, 2006 to 2009. That's correct.
That is correct.
And then again, until 2019, just explain that one. So you moved from DSO, but when you moved to NPA, it was still the same position.
It was still the same position. It was when we were disbanded, Minister.
Yes.
So you kept your rank. You, however, chose an office, and I was allocated by choice to the DPP office in Pretoria.
In Pretoria.
Yes.
And then you moved then to the head office from 2019 to 2022.
That is correct.
And then you became the head of investigating directorate from 2022.
1 March 22 to date.
Till to date. Okay. Then we move, this one you're saying you moved from 2022 no? to date.
To date.
Okay. And then as we look at that, in terms of your work experience, if you can tell us in terms of your areas of involvement in law, as per the areas. I see here you've flagged some of the issues, your legal background, in terms of the areas, criminal law, all matters are related. Administrative law, you didn't explain much. You just said none except labor matters. And then on constitutional law as well, you just said that it's just filing papers. Maybe explain that. You didn't provide more details on that one.
So in terms of the administrative law, I always, and if I'm wrong, I'll be corrected, I always saw the involvement of prosecutors in the disciplinary processes as part of an administrative process. And so that is where the overlap between administrative as well as labor, because it is a different issue, it is also dealt with differently, Minister. And that, I hope, clarifies. In terms of constitutional law, it is in relation to the criminal work we do, but in the matters where applications had been brought against the NPA, to wit in some of our matters, both in the Celebi and the Pistorius matter, there was then the filing of constitutional law papers, applications being filed in the Constitutional Court. However, in both those matters, the NPA was fortunate in that the justices decided on the papers and therefore did not need to hear us on both those matters.
Okay.
But that would be the full extent of my involvement actually in the constitutional law framework, Minister.
And I see you've been appearing in court. You stopped appearing because you are now head of IDEC.
My last matter, yes, was November 2021. I had always liked to prosecute. I was one of very few deputies or a senior deputy that still wanted to go to court. I did organized crime matters. I had an affinity for cash in transit matters, organized corruption, crime matters. So yes, I was in court. And I think that also helps me a lot. I get to see people differently. and I get to see the institution differently.
Okay. Let's go to your managerial level in experience. I think the Section 3 deals with prosecutorial experience, which we have dealt with. You've been a prosecutor almost all your life. We're moving into the managerial experience. You've not given us more in terms of what you are currently managing. I see here you're saying, I have supervised at any given time between 20 to 30 people.
That was
this
before,
is only at IDEC.
Before IDEC.
Before IDEC.
Before
it says
IDEC.
at IDEC. Okay.
Yes.
Take us through.
So how it does work, Minister, and I'm sure that you and the panelists are aware, when you are in the office of a DPP or you are the coordinator of a specific component, there's very few persons that you are responsible for, and that would limit the numbers. In my time at the DSO, I managed investigators, prosecutors, we managed analysts, and we managed the cases. But it wasn't more than 20 or 30 at a time. So
at the DSO?
At the DSO.
Okay.
At the DPP office, when I went there, you manage a team. It depends on which cases. Most of the time at organized crime at the DPP office, we did have a coordinator of organized crime. I was a deputy there. I then managed those persons whose cases I oversaw. And you also then managed, Minister and panelists there, every day administrative issues. So whether it was leave, whether it was discipline issues, whether it was resource allocation, case allocation. But in the main, one managed their operational issues. And then as a manager in the office of a DPP, you then form part of the senior management structure of the DPP. And so you attend to ensuring that we achieve the annual operational plan, you make input into the strategic plan, and you ensure that the strategic objectives of that division and or component are achieved.
Okay. In that office, how many people?
In the office of the DPP?
Of the DPP, that you were reporting to you?
In the office where I was at the organized crime component of the DPP office.
So because of, based on the number of cases, it will be between 6 and 7 at times?
Give or take, yes, that is correct, Minister.
Okay. And then now with where you are,
at IDEC,
you can have your water.
I hope you don't mind, I have juice.
No, we don't mind.
Sorry.
Feel comfortable.
My sugar levels were running low.
Okay. No, it's okay.
So thank you. At IDEC currently, we are a staff contingent of 128. As Minister is aware, we are only a national footprint at this time, even though we have cases over and beyond the province of Gauteng. We are 63 females, 65 males, and we have quite a varied representation also in terms of our race equity. And we are quite proud that we are 63 to 65. And I think as the gender equity, we might overtake the males soon enough. We are still busy, Minister, with recruitment. In fact, last week, financial investigators were being interviewed. There were 33 positions, and interviews happened over a span of 3 days, 11 per day, and that process continues. So the staff contingent will grow, but the management currently is of 128, which includes myself.
And that's besides managing the Section 38s are managed by you directly? Or by various advocates?
The Section 38s, I have engagements with them. It is preferred, however, Minister, that the Section 38s are managed by the Deputy Director who oversees that matter, given that it is a prosecution-led model. And because we have to account for the work, I would not be able to account legitimately for the work. Auditor General knows that when we sign for things, we must be able to say work was done, money is to be paid. So the practicalities are that they fall within a team.
And then tell us about your management style. You didn't highlight. Your form is highly summarized, so I'm going to probe quite a lot from
Absolutely,
you.
As Minister is entitled to do. Sometimes I think that I'm too much of a people's person. But I think that has held me in good stead.
What do you mean by that?
I am consultative. We must talk to one another, top down, bottom up. It's not slogans. You know, Minister, when you come into a new unit, one that must still stamp its footprint, you have to know yourself. What that meant for me was, what would I want from the people who come to IDEC? And you cannot have them guessing. So it was lots of meetings. It was lots of operational meetings, getting to understand the landscape and what had come before me. My management style is to know my people. I pride myself. I'm perhaps one of the few who knows, if not 90% of the staff by name. I may not know everyone by first name. I will know them by their surname. I take the time to get to know them, because if you do not know your people's strengths and weaknesses, it becomes an impediment to how we operate. It becomes an operational issue. And I think the one last thing there for me, in an environment such as ours, it's not just gender and race and cultural diversity. We are bringing together people from different capabilities, different qualifications. Everyone knows better. Investigators want to be better than prosecutors. Financial investigators are better than criminal investigators, and vice versa. You have to be measured. You have to be tolerant, and you have to be understanding. And I think that has been how I have conducted myself.
Some people say that those who are consultative, they tend to be indecisive.
Consultation does not mean indecisiveness. Mm-hmm. In an environment such as ours, the first 2 years were consultative.
Okay.
Since IDEC became permanent in 19 August 2024, trust me, Minister, we have to be decisive. We are permanent. What do we need to do? We were given an opportunity 2 years prior to map the landscape. We are decisive in the things we do.
Okay. Let's move to the next segment, which is segment 5, section 5. You have indicated here you have not been suspended for any position. You've never been subjected to any disciplinary process.
Correct.
Can I confirm that? In terms of your office, in NPA, we've got the Office of Ethics and Accountability. Have you been reported there?
I did receive a letter yesterday. Mm-hmm. That as a result of the complaints, one of those was escalated to the Office of Ethics and Accountability. I'm not sure what was sent to them. I just received a letter, Minister, that said, we have received a complaint. We will not be looking at it. It has been escalated to the Office of the Minister. But that was yesterday. I cannot give you details. I do apologize. That is what I got.
The ethics office didn't look at it.
The ethics office looked at it and said they will not be conducting a pre-investigation. The matter is referred to the Office of the Minister.
Okay. I have not received it. We'll look into it. But as far as we know, there's nothing that currently has been lodged. Okay. And in terms of a complaint brought to you against anybody, you are saying none. Are you a member of anybody?
No, Minister. Except for, I think as prosecutors we are automatically members of the Legal Practice Council. But I should say, way back when, prosecutors were asked to be members of a union. I am a member of a labor union. I have been since 2000, as are all prosecutors. I think whether you're at the PSA or wherever it is you are affiliated. But that is a membership. I don't know if I don't want to miss anything.
IDEC is allowed for you to be a member of a labor, you know.
It's
senior management that is not supposed to be members of labor?
I know that we all, I know many of us way back, I think this happened in 2000. I'll have to check my membership. Please I've never used it, Minister, to be clear. I've never had cause to use it.
My understanding is that the minute you become a head, you shouldn't be, because you are now part of the employer.
Yes, I've not used it, and I don't know. If something has to be rectified, of course I'll rectify it. Not having used it, Prof, I'm not sure what the rules would have been.
I just want to check, when you say you've been a member since 2000, surely there are interactions if you're a member? Either you pay or you get correspondence, or are you saying it's a dormant membership?
I have only back in 2000 when I became a member, I know that it goes off my salary, but there haven't been communications because I've not needed to communicate, and they haven't communicated with me.
And it's still deducted up until now?
I'm sure that it still is.
Okay.
I don't want to say no. Then someone looks in my salary advice and it is. I will look, and Minister, I take your point. And I think it falls away in the sense of I've never used it, it's there. I do understand my responsibilities, forming part of a management where I'm an employer, and I will make sure that if that is an issue, that must be rectified.
I'm trying to check. We tend to be more vigilant for our own bank statements, so that even that 99 cents that is deducted for
Yes.
apps, you mean you haven't checked?
No, I'm saying I'm sure it is still being deducted, but I have no communication over and beyond the deduction from my salary.
Okay.
Thanks, Minister. Advocate Johnson, we have to get this one clear. You not having that engagement with the union
Yes.
does not impact on the validity of membership. You're saying you are a member, so the fact that you have never accessed the membership benefits,
Not at all.
that is actually irrelevant in as far as the validity of your membership is concerned.
Understood.
And now I just wanted to understand, is it your position that you were not aware that as a manager, senior manager, you are actually not supposed to be part of a union?
Absolutely.
Okay, thank you.
And hi, Advocate Johnson.
Good afternoon, ma'am.
How are you, ma'am?
I'm good, ma'am.
Thank you. And you are saying your specialty has been labor law in the main?
No, criminal law.
Criminal law?
Yes.
Oh, okay.
Only
so
criminal.
labor law came in only when you are representing or dealing with NPA labor law matters?
Yes, and in all of those, I have only chaired in the labor law matters. I have not represented any employee in the labor law matters, given that as a senior manager, I saw that as an impediment, and we had long debates about those back in the day. But I had only chaired in labor matters of the NPA.
Okay.
Sorry.
Okay.
This is interesting. Advocate Johnson, you are a lawyer, right?
Sure.
And for all intents and purposes, if you were to chair any disciplinary hearing, there would be two parties there.
Correct?
And for all intents and purposes, one would be represented by an employer representative or an employee representative.
Correct.
Didn't you get curious, having signed the form at one point, about the fact that there is this relationship that you have with this body that actually appears before you as a chairperson in a hearing, and you are a manager, senior manager in the space? Didn't it occur to you, at least for you to be a little curious?
I haven't been, and I know that it's
Sorry about that.
sorry, I do not want this to seem as though it's a glib answer. It isn't a glib answer. It didn't occur to me because I was just doing what was within the mandate and what was expected of me. I chaired the disciplinary knowing that I had to be objective on all fronts. Who appears should not be relevant. It is the evidence that is placed before you. That is all that I could and did adjudicate on. If you start to wonder about parties, you make yourself prejudiced and biased to the process and should therefore recuse yourself.
No, Ms. Johnson. That's not even my point. My point is simply, you are a member of this union, you have joined it. And my colleague sitting there has said to you, the fact that you have joined this union means that there would be deductions, whether you received service or not, it's not the issue. All that I was at least interested in from you in this context is, having been a senior manager for that long, didn't it occur to you that for all intents and purposes, I've been a member of one of these unions, not on the basis of whether you like or you dislike any of the parties, or you have to believe or not believe them, because that was not the part you had to adjudicate. What you had to adjudicate is the complaint that is before you, not the persons that are before you.
Correct.
But then I wanted to understand, that's why I asked you, didn't it occur to you to be curious one day, Nje, to just wonder, what happened with my membership with this union for the past 25 years? That's all that I'm asking you.
No, sir, unfortunately, I didn't.
No, that's fine. Thanks.
Chair. No, thank you so much. Good afternoon, ma'am.
Good afternoon.
It's very interesting because, I mean, I just want to ask you a question. Is it the same if you're in a disciplinary hearing and the person is in front of you, the union rep is there, is it the same union or is it a different union? All the staff members in that unit of where you are, how many unions, perhaps I should ask how many unions are there, because there will be a majority union and which will be recognized, and if you're a member of that union and there appears to be a disciplinary hearing and here you sit and you chair and there's a union rep and there's the union member and you're also union member, doesn't that constitute a gross conflict of interest?
So, just to be clear, sir, I think the last disciplinary I chaired is well over 10 years ago. And I cannot remember which union would have appeared. But what I can say is in the past 10 years, I haven't chaired any disciplinary matters. And I am not aware of the memberships of the staff at IDEC. I think the only one that I am aware of, only because staff would indicate the PSA is having a meeting, and they would usually go to the head office at the VGM, but I'm not aware of their affiliations, to be clear.
Thank you very much. In these disciplinary hearings, there usually would be a declaration of interest up front. And I'm sure you might have gone through that exercise. And at that point, even if it's 10 years ago, did it occur to you that you'd also say, I'm a member of a union, even if my membership I'm no longer actively aware of? That's one. And also, as senior managers, when you are negotiating salary, unions are negotiating this or that percent, didn't you take interest that my union is bargaining for this salary? Yes, I'm a senior manager, and so forth. What will be the outcomes and so on? Or even unions coming to say, as a member, would like you to advise us on A, B, C, D, E.
So on the second point about the salaries, you will find, Prof, if you speak to people at the NPA and colleagues who'd come with me a long way, that was one of the lesser things I did worry about. And I hadn't ever been approached by any union, let alone the one for which I have a membership. I left salary issues. As a senior manager, that had always been my take. If there is a salary progression to be given, we will be told by the NPA. I didn't engage. I never asked anyone to engage on my behalf either, not in all of my career, because that isn't why I was at the NPA. I am aware of colleagues who would have, but I didn't. And quite a few of us, by the way, I'm not a saint, quite a few of us did not, because the work came first. In terms of the first question, Prof, I honestly cannot recall. I know that we had to sign forms. I just cannot tell you which ones I would have signed at the time. But if it is an issue of contention, I would rather go back and look at it than give an answer that I'm not confident of.
Let's move on to this one. Let's move on. I'd like to go through the form section 6 on the financial and proprietor. Can I confirm that you hold no directorship,
Correct.
nor any business interest?
None.
Okay. And you have declared that there's no health issues that would impede you from doing any of your work?
None.
I don't know if it's me who's mistaken, but I noticed on number 4 you didn't tick. Have you ever had civil judgments, maintenance order, debt review order?
Not. I think
You
that's
don't
a
have?
standard, yes.
Yeah, because I see there on 9 I didn't have that, so I wanted to check that one.
None.
Okay. I think that's the questionnaire we had with you. Then I'll move to the next segment of our questions that will come also link even to performance, which other members will follow. Now, you've just taken us through what you are doing at IDEC and having to lay the foundation for 2 years, and therefore since 2024, formally starting to even fill the vacancies and closing. If you can take us through the vision, should you be appointed as an NDPP, what are the issues that we'll have to deal with and how will you respond in looking at where NPA is today and what you have as a vision of it for tomorrow?
So Minister, if I could start with performance. Currently, in terms of the NPA's performance, the 3 areas where the performance is not what it should be are the areas of corruption, the area of GBVF, as well as the area of organized crime, in terms of what is ordinarily called serious organized crime, dealt with by the DPCI, the Hawks. Coming in, what a national director would have to do is to understand what is it that we do not have, that we need to have as prosecutors and as an institution. What is glaringly clear is that in terms of the capacity, all of those specialized units need more capacity. But numbers doesn't of necessity equate to performance. We therefore need capacity that has the relevant capabilities. And to that end, Minister.
Explain that.
To that end, we need to ensure that the prosecutors are trained in those relevant fields. When you look at the aspirant prosecutor program, from what my limited knowledge, it tends to be quite generic. The prosecutor program has got to aim to attract and retain a higher graduate than what it currently does. It must also ensure that the prosecutors coming into the aspirant prosecutor program are not just trained on general crime trends that they have to prosecute in the lower courts. They must know what the NPA comprises of, what their career path will be, and we have to ensure that those in those specialist units also make input into the curriculum and the training of the aspirant prosecutor. We need individuals who will also be able to understand what the performance output of the NPA must be. You see, Minister, where we are, we often make the mistake and say to staff in a very generalized way, for performance, we need to prioritize. What does that mean to prosecutors on the ground? How does that equate to performance? And I say that is where our ability to communicate with our staff becomes important. A national director must ensure that the entire institution understands, one, the strategic objectives and what we need to do to achieve those. One may say, but as a national director, there are special directors, there are directors of public prosecutions. That's their job. I beg to differ. A leader must ensure that his or her people understand what the institution is about. what their role and function is, and what they will bring through their performance to the indicators and to the achievement of the NPA. So performance, together with training, becomes a critical exercise. I am aware also, Minister, that we have programs with School of Prosecution at Justice College, so that it's over and beyond the aspirant prosecutor program. Existing prosecutors are also going back for touch-up courses, an important course that they're going to go for, which had already started. And what I like is I think we use a retired judge, and we also use outside counsels on leading expert evidence. It has been a shortcoming. It therefore limits our performance in specialized areas. It also means then we are unable to achieve our indicators. We also then have, through the School of Prosecution at Justice College, money laundering training. But then we have to say, how does an NDPP and an NPA change the game in terms of the specialist units? What we are doing is, through the German-funded training, which Minister is aware of, that there is specialized training on organized crime as well as complex corruption. But the training then, which is quite different, is not just for the NPA. In those training programs, Minister, we have investigators from the DPCI as well as the South African Police Services. I know we have spoken to colleagues as well from the revenue services that where applicable, they are able to join those. So what it's saying is we are looking at managing the NPA's output differently by ensuring that we have a better, more capable staff. And then I think the last one for me would be, in terms of the main categories, is the morale of staff. We should never take people for granted, because disgruntled people can become quite an impediment to your operational activities and your output and your performance. You need to understand what brings their morale down. Is it just people who are disgruntled and grumpy? Is there legitimacy to the complaints and or the unhappiness they feel? And it becomes important that you don't take it for granted. But if you have the staff understanding that our work is to serve the people of the Republic, and we do that by ensuring we put out quality prosecutions based on evidence and the law, and that they are valued because that contributes to the output of the NPA, I think that is one way that we'd be able to just change that morale. And also, don't let people think that you favor one above the other. That would be the biggest mistake. Not all of us are equal. You do tend to build relationships better with some than with others, but you should never isolate staff and never let any category feel as though they do not bring something to the table. And where they don't, you've got to engage. Have your managers engage them about what it is that is going wrong and why we are not getting to where we need to get to as an organization.
Looking and listening to what you are raising now, Advocate Johnson, I go to your performance as IDEC and look at the statistics. This is the report that we've just tabled before Parliament. And it goes with the issues that the public have been raising about, and you are saying, and correctly so, you have identified the areas that NPA is not doing well in terms of stats on convictions. Corruption, GBVF, organized crime. Corruption falls under your work. And I look at the report, I see in terms of authorized investigations. I look at enrollment of cases versus what is expected. If we look at last year, we've moved from 2023-24 from 3 to 9. But if you are to look at the report of what would be expected as investigations, where, for example, you would have accused persons of 177, someone's entities about 22, but I must read it properly. Yeah, I'm reading it. If you look at that stats that we've provided in the report that we provided versus what we have as enrolled to court, that stats doesn't look good.
And I appreciate that. And if I may explain.
Because we need to understand, and I said to even this is consistent. I don't want to be told by the public that you've moved from one problem, you've made it a national problem. If it's a problem of performance is sitting at IDEC, maybe we have an opportunity to fix it there. But if we take you and bring it to NDPP, then we're expanding the problem of non-performance. Maybe share with us what is happening, why this performance?
So and I can speak for IDEC then, Minister. Yes. If you take IDEC, you would appreciate that when IDEC was formed by proclamation in April of 2019, it didn't have permanency. It didn't have a permanent structure. It worked on seconded individuals or duty reassigned from the DPCI and some from SEPS. When I took office in March of 2022, there were only 22 criminal investigators. There were a few more prosecutors than criminal investigators. And we had the majority of the staff that were there, financial investigators and other prosecutors, were all on contract. We then moved into dealing with the matters and enrolling the matters that we could. When IDEC then became permanent, Minister, you do see that there is a difference in the performance because we do have a bigger capacity. We don't have all the capacity, but that is not an excuse. We do have a bigger capacity. The cases themselves are voluminous. And Minister would appreciate that what we have to do is to be sure of the matters that we have to enroll when we enroll. We have been challenged and criticized, and legitimately so. If you take the matter of Matsela Koko, we received criticism that that matter had been enrolled, and then the matter was struck off the roll. And to explain, because these matters are so large, if you are not careful and carefully consider where you are with the evidence, what else is left, what specialized services are required, we enrolled that matter earlier than we should have. That was a lesson we took. And in taking that lesson, we seek then to make sure that our matters are better prepared. The investigations are finalized to date of enrollment. We have ring-fenced matters so that we don't have open-ended investigations. You will appreciate that the matters that are on the roll, if you take the Transnet transaction advisory, if you take the Transnet locomotives matter, you take Alexco, etc. These are really big matters, Minister. And so we wanted to ensure that the matters are as ready as they can be when we enroll these matters. We had to take that lesson learned. When you make that kind of error in judgment, the public has every right, as they did, to criticize us. We have to show that we learned a lesson from there. So in terms of the enrollments, it takes longer because of the volume of the matters. But you will see that there are more investigations authorized than previous. It's because we now have a bigger capacity in terms of criminal and financial investigators, so that investigations are now churned out much faster than they used to be previously. Is it a satisfactory scenario in terms of the numbers? No, it isn't. But what it does say is we are careful about what we enroll, when we enroll, and we have to be sure that our enrollments are based on the evidence and the law. These are cases that affect people's lives. And so when we are accused of prematurely enrolling, it does not bode well. So those enrollments are key enrollments based on the year-to-year target. And although we've met the year-to-year target, and we will as well this year, both in terms of money laundering, investigations authorized, and prosecutions enrolled, we have met the targets each year. But it is slow.
Are this the only one, the Matsela Koko matter? Because there are quite a number that we would not have done well. Or the Newman one, we were managed to appeal. You appealed and then you won. You got the appeal.
Yes.
And then, is that the only one that has fallen off out of the matters that you're dealing with? There was a withdrawal representation of matters as well?
No, there was one. The other matter, Minister, the court struck the Estina matter off the roll in August last year.
Yes.
And what had happened there is we had made disclosure to the defense a year before, and we were in court in August of last year. In April, I believe, we made electronic disclosure of the hard copy disclosure we had made. And when the accused appeared in court in August, they said to the court they didn't have enough time to go through the electronic disclosure. However, that which was electronic had already been made available in a different format a year prior. And that matter was removed from the roll for those reasons, because the court correctly felt that if you look at it, they should be given an opportunity to go through every medium of evidence that they are given. And for that reason, that matter was removed.
And this change of strategy, where you say you've learned, you're saying, as IDEC, we have learned that enrolling prematurely and therefore we have changed. When was that change of strategy?
That change of strategy happened, Minister, shortly after the Cocoa matter was struck off the roll. We had to sit down and we had to understand why that matter got struck off the roll. When it got struck off the roll, two key areas of work were still to be done. We estimated it would take between 6 to 8 months. It was for the digital forensics and the financial forensic report. Unfortunately, it was not finished in that time. So these were a specialist field of work on both areas. So we had to sit down and say, given what sets us back, we have to deal differently with how we work out the time frames for completion of that work. It's also become easier, Minister, because procuring the services is now easier. We also have Section 38s on board, together with the prosecutors, and the ability to assess the matters are done quite differently.
Then going back into the role of becoming an NDPP, as you have reflected on the GBVF stats, that is not satisfactory together with organized crime, and would agree these are the two areas that the public would not understand why we are not doing well. Should you be appointed, what would you do differently in these areas?
So, Minister, I really became keenly aware that the NPA was not doing well in the GBVF in September last year. And you would appreciate it's not my field of work. And we were in Parliament. And I remember it very clearly. I think it was the 11th of September. The previous minister, Mesa Malani, went with us to the Justice Portfolio Committee on a different issue. But Mem Kwebane raised with the National Director if she could explain why in a quarter in the Western Cape, 245 GBVF cases were withdrawn. I heard about that for the first time. And that became a reality. I remember that when we went back, I do attend the EXCO meeting, which is the NDPP and her deputy nationals. And I raised at the meeting that what did we do wrong? It might not be my field of work, but what has the NPA done wrong? And one of the suggestions I remember making, only because you cannot come up with a solution when you don't understand. I asked if we could ask the special director and or the DPP to please provide the reasons for why those matters were withdrawn. What were the lessons to be learned? Because you cannot have, in one quarter, 245 is a number way too many and unfathomable. I am aware then, given those engagements, documentation went out from the head of the NPS at the time that this exercise is to be done. But what also then brought this matter more keenly to the fore was the Omotoso matter. And so this is what we had to grapple with. And I sat in some of the engagements because I was also unable to understand what we do, Minister, if I may. In the corruption matters in IDEC, we have a whole host of people that sit together. They are a team. But before matters are taken to court, we have an advisory panel. The advisory panel must be presented with the evidence, the challenges, the charges. And this is a panel that has nothing to do with the cases. That panel is also not an IDEC panel. It is from members in the Specialized Commercial Crimes Unit within the broader NPA. They also invite investigators to that body. It gives us a different method of assessing our matters. And I couldn't understand why we didn't have that in sexual offenses. And so for me, what a national director is supposed to do is to understand, one, what is the NPA's GBVF plan? Is it sufficient? I understand that there is a plan. I understand that with the GBVF now being declared a pandemic, that there has to be a different methodology. I think the methodology talks to our specialization, and are our prosecutors on par with what is required. What has become clear is if these matters were withdrawn, and I would assume invariably in the lower courts, which would be the regional and the district courts, it means that we have to get in there. What is the training that is required? What is the relationship between prosecutors, not just victims, but those who can provide a service to those victims? Are we using the TCCs? Where there's no TCCs in an area, Minister, who does a prosecutor activate to ensure that victims are prepared for court, not just through consultation with the prosecutor? What specialized services does the victim need over and beyond, I think, the psychosocial, medical that is provided through the TCC? But there has to be a different engagement between the Special Director of SOCA and the DPPs and those prosecutors. Who's keeping track of these high-profile matters? When do they keep track of the high-profile matters? Someone must intervene and engage. So whether it is the Special Director or the DPP who engages with the prosecutor, they have to keep their finger on that matter. What do their people need? Do they know that that matter is a high-profile matter? Have they assessed that matter correctly? And also to have ongoing training in terms of dealing with GBVF. It's a very sensitive matter. And I think in the manner in which I just generally understand how it is conducted, it cannot just be, it is a case to prosecute. It has its own nuances, and prosecutors need to understand what those nuances are. So as a national director, a national director has to make sure that the plan is implemented. Relationship with stakeholders internally and externally is being optimized, and that we have enough facilities to prepare our victims and witnesses. Because one of the complaints that I did see is that at the last minute, victims and or witnesses do not want to go to court. When they do go to court, they're not as prepared as they should be. They falter and or fail in cross-examination, and that talks to us as prosecutors and whether or not we prepared them properly.
And on the organized crime?
On the organized crime, our relationship with the DPCI as well as the detectives organized crime is critical to how the NPA operates. And given that the NPA works on the prosecution guided investigations, I've always had a challenge if prosecutors write long notes to investigators. Do this, do this, do this, do this. It has to be prosecution guided, as in sitting down with the investigator, understanding what that matter needs. Now with organized crime, Minister, there is an organized crime strategy that was formulated by the NPA in consultation with the stakeholders. It was signed late in 2024. And what that seeks to do is to engage with different stakeholders, with SARS, with the FIC, as well as the DPCI. And what it seeks to do also is to have a better engagement with crime intelligence. The organized crime cannot be dealt with if we do not have credible intelligence, and crime threat analysis point us to modus, it points us to groupings, it points us to commodities, and it points us to what it is they are doing. If you take that, you take the investigations by the Hawks, guided by the prosecutors, organized crime can be dealt with differently. For me, the strategy, though, cannot be an NPA-driven strategy. Organized crime is a country problem, and I do appreciate that there would have to be more engagements, and there has been buy-in by the police and the DPCI, but we need them to be signatories to the document so that implementation is a proper buy-in and everyone understands their role and responsibilities.
Okay, before members do follow up on my issues and take over the question, just one thing that I observed, which was quite an interesting thing I saw. You've got on your reference Mr. K. Behari.
Correct.
What's your relationship? Friends, colleagues?
I had known him for over 35 years. Is it a week ago? He was suspended. I called him. I hadn't spoken to him in months. It's not somebody I engage with every day, but it is someone I've known for a very long time, Minister. I spoke to him.
How do you put somebody, when did you change your reference on your CV?
The documents had already come in.
Oh, okay.
So I chose not to change it. Okay. I knew that if any issue arises, I must answer the issue. Okay. Changing it and then resending does look like I have something to hide, and I have nothing to hide.
I'm talking in the context when you say you have not spoken to him.
No, he had been a reference. If you look at my CV, Minister, those two references had been references perhaps for the longest time. Okay. On the CV, and had been there as well in the previous interview for NDPP. I called him and said to him, look, I had been nominated and I accepted a nomination. I cannot have you as a reference on my CV. I, however, cannot change it now because those documents have gone through. I did inform him that I will inform the panel, as I do, that he cannot be a reference on my CV. However, I must say, Minister, I did ask about the reasons for his suspension, which he did provide. And I did say to him, while I hear you, you have to appreciate, I am not judging you, but I cannot be having you on my CV. So I unfortunately did judge my friend, who hasn't been found guilty of anything. But in this position, the perceptions do matter. And Mr.
Yes.
Behari has understood
that's why I'm
that he,
it, as
that
head
he
of
will be.
IDEC, and with what is coming at the commission with reference to Ekurhuleni, I got concerned to see him as your reference, and that's why I wanted to ask the context of your relationship with him.
It had been such an old reference. I think even if I had to print CVs from prior, him and the other reference had always been there. The suspension happened after the nomination and CV submission, but I did tell him I have to remove him, and we also agreed that given the allegations that are made, given the fact that he is suspended, although we hadn't talked for months, we will not be able to talk at all till his issues are resolved. I did stand in judgment. I might lose much more friends because I am judgmental, but I had to do that because in the seat that I'm sitting in today for this position, the perceptions do matter, and I've had to do that.
Prof, you want to say something?
As the head of IDEC, I'll assume that your first instinct is vigilance and
Correct.
verification.
Correct?
And it does look like in some instances you allow for this profound blind spot. Because let me escort my logic.
Sure.
When you are to put someone for reference, the common practice is to go back to them and talk to them to say, I have applied for A, and now I have applied for B. I've applied for C. There is no retainer in reference where you say you will always be there.
Understood.
So it would look like you have not spoken with the person for months, but you were able to utilize their reference as such. You verify if the number is still the same, the address. Are you in agreement? Because at times some people will say, I cannot be referenced for this particular one. That's one. The second one from your previous answer is the one of most of the time you talk about the reforms that ought to be made based on precedents and what you have encountered as the NPA or IDEC. What I've not seen or heard coming out clearly, it's the strategic foresight to say this is the emerging trend of organized crime or corruption which will define the future, because you may resolve things that have happened from the past and have to go back to the drawing board for those things which are coming very fast into the future of crime and so forth. Would you comment on those two? I would have added the third one, but I know that my chair will say don't overload or front load. Yes.
Prof, I take your point, and I'm being as forthright as I can be. I'm saying to you those two references had been there. When I was nominated, I sent the person my CV that nominated me, and I sent it as is. I did make a few amendments in terms of things that I had done since then. I didn't think I needed to call them because I know his number didn't change. I hadn't spoken to him in months, but he's always had that same number. And I am aware he's lived at his address for quite some time, and I was not aware that he had changed. And I think given
So
that...
that one, when was the last time? When you say months, when was the last time?
That I spoke to him. Minister, it could have been February or March, other than now last week, when I did call.
February, March this year.
This year.
Okay.
Yes. And I hadn't been to visit him in more than a year and a half, if not more. And with the other reference as well, there's nothing wrong with the other reference, but I also didn't call that reference because it is someone that I know her number has not changed. And I didn't think about the address. It's the reference and that they are contactable. But with Mr. Bihari, I known him most of my adult life for over 35 years. And when there was cause, Minister, to contact him, then I did. In terms of reforms to be made and the strategic foresight, sorry.
You just mentioned the second reference. I was going to come to it. Also, it's problematic for me. There's no position called acting judge in the Department of Justice.
I appreciate that, and that is my error. She is a magistrate, a regional court magistrate at the moment. That is, I'm saying I didn't change those things at the time, and that it's carelessness on my behalf.
Advocate Johnson, there's never been a position called acting judge. You are either a senior advocate, because acting judges come a week or two sessionals, but it's not a position.
At the time, she was acting as a judge in the High Court for a term.
Yeah, a term is 6 weeks. Yes, because I signed the appointments of acting judges.
Yeah,
so
this was
a cycle, it's 6 weeks maximum.
I take
Others,
it.
for example, now, the acting judges will be now in December, when the normal judges are on recess, so that they can hear urgent matters. So it can be a position. I'm trying to flag that. Because I'm looking at this, it says, name of referee, Ms. Mngube, company, DOJ, position, acting judge, Pretoria High Court.
That was at the time. That is my error, and that is what I made the point. I sent my CV. I didn't change my references. She is a magistrate, and I apologize. I didn't change it.
So she would have been a magistrate under DOJ?
Under DOJ, and still is, Minister.
Okay. Answer the other one.
So in terms of the reforms to be made and the strategic foresight, Prof, the reforms are made within the various business units. And they are made where we do sit together for the NPA strategic plan, and it is in part of that planning where the strategy was that in order to deal with organized crime, there hadn't been, for example, a country organized crime strategy. Not even the police have one, Prof. They have standard operating procedures and they have how they work, but there wasn't a national organized crime strategy. That is part of the strategic foresight of the NPA team, that we need to formalize a strategy that is able to deal with the crime threat, which is organized crime. in doing so, I am aware that there were lots of consultations with people who are in the field, experts in the field who helped guide the strategy, as well as then with law enforcement. With the corruption, the strategy in IDEC has been to deal as holistically as we can with the various corruption matters that we have, and to ensure that they get enrolled. But I can see Prof's hand. I may not have answered it in the way the Prof anticipated.
No, he still had other questions as well.
Oh, my apologies.
I asked them not to go too much. They just ask questions, you answer, and then they can do a follow-up. Proceed, Prof.
The reason I invoke the issue of strategic foresight is that, for the most part, either you talk of IDEC where you are, but we wanted you to lift your gaze to the horizon of a vision
For the NPA.
for the NPA. And that is where I was trying to say, can't we lift that gaze? Because you'll not be appointed back to IDEC should you be a successful candidate.
Understood.
But having said that, you mentioned twice the meeting of targets.
Correct.
Would meeting of target generated by your institution or your unit be the same as having an impact? Because there's one compliance matter where people say these are the targets. There's another one where you say, no matter the targets, the needle is not shifting. Can you reflect on that?
And correctly so, Prof. I know that there has been much debate. Even when we go to Parliament, Parliament has asked, well done, you've achieved your target. But what does that equate in terms of impact on the people whom you serve, which would be our South Africans, regardless of the crime type? And that is an issue that I know that we have been discussing in the NPA overall. How do we measure impact? Targets are numbers, but do those targets deal with the right cases, the cases that can elevate what we are doing? So if you take, for example, I remember there's a matter, it's a corruption matter not in IDEC. It deals with the Lepelle Water Board, I think in Polokwane. And because of the fraud and corruption there, it was identified that the corruption in that matter must be dealt with. What it did is, if you deal with that matter, and if asset forfeiture is able to bring back the money, one might be able to put it back into the criminal asset recovery account and therefore give government the impetus to then put in a water supply for the community that was robbed of its water supply because of the corruption. That is how I consider us defining impact. Targets are numbers. And so what we have to do differently is understand which matters affect the South African population. So impact can be measured differently. It is what kind of recourse do you give to a community when you address the crime in that community. It's the same with drugs, Prof, is dealing with drugs and dealing with drug syndicates may bring relief when you arrest those persons. But in other matters, you need to be able to recoup the money so that services and service delivery goes back to a community. That, for me, is the impact of matters. Targets are part of performance achievement. They are part of the indicators, but not all targets talk to impact, because you have to identify those matters that will make impact across the board.
Thank you, Minister. Advocate Johnson, admittedly, humanity is fallible. But the position that you hold requires a higher degree of care and skill in the execution of your function.
Correct.
Now, I'm raising this issue at the backdrop of the two cases that were mentioned earlier, which you readily admitted to have not handled properly. The Estina matter, as well as the Coco matter, that they were placed on the roll prematurely, and that you've drawn lessons from such mishaps. But the higher standard of care and skill wouldn't permit us to just brush it aside and move on as though it's business as usual. Because that higher standard of care and skill does not, regrettably, allow a space for complacence. And my view and take in handling of these two matters points towards you having been complacent and having exercised poor judgment in enrolling matters prematurely. Now, now,
let me finish.
Yes.
Sorry.
Now, this talks to consequence management. Reverting to my earlier sentiments, it cannot be, and these matters cannot be treated as business as usual. Surely there should have been consequence management, looking into the calamitous effect of having such high-profile matters withdrawn due to lack of readiness on behalf of the state. Was there such consequence management applied to you specifically, other than just having drawn lessons from such mishaps?
The Estina matter, just to be clear, was not a premature enrollment. However, the court there felt that the evidence that we gave, albeit that we provided it to the defense a year before, because we provided it in a different medium later on, they should have been allowed an opportunity to go through that. So, but in the Coco matter, yes, we took the lessons, but I take the point. The national director did call me in, as I reported to her, and we had to provide a report on how we made that kind of error in underestimating, and the only error was the underestimation of time to complete those specialized services. The national director did indicate to the team and I, as we were all called in collectively, that the matters need to be adjudicated differently. She did talk about what you mentioned, and that we should have more care in how we enroll these matters. So I'm not sure how far the consequence management should have gone, but we were addressed. And that was part of how we now, in terms of the question also by the minister, where one would expect there to be more enrollments, there aren't as many enrollments because we exercise a duty of care more diligently, given what had happened with that premature enrollment of the Coco matter.
So that was just a slap on the wrist. There was no disciplinary action whatsoever taken, notwithstanding the consequences.
So in terms
or
of
the effect that this had, not only towards the proper administration of justice, but in perpetuating the erosion of public trust in prosecution.
I know that for myself personally, when it came to my performance assessment, I received a score I had not received in my 28 years at the time of being a prosecutor. The national director marked me down to a 2 as part of my not having performed as I should have in that area of work. But that was as far as it went, and I take the point. I can't take it any further.
Okay.
That is what was done.
Just one last point. You indicated that you got to know of the impact of the GBVF when you
Went to Parliament?
When you were in Parliament, and that was the first time you got to be aware of the impact, or rather the statistics and the challenges that bedeviled the institution at the time. And part of your reason for being oblivious to that fact was that was not necessarily your area of focus. But you're sitting here today as a candidate for appointment to the highest echelons within the NDPP. I would take it that you did not develop interest in this position overnight. And I take it, if I'm correct, then you should have had interest in broader areas of performance within the institution. And by your own admission, you didn't really have demonstrated that interest, because you had proximity to management, you had proximity to access reports that will inform you of the direction the institution was taking, and you missed that opportunity.
May I expand?
Yes.
So I wasn't oblivious to GBVF. You cannot be a woman in this country. And I am the mother of a girl child. I'm not oblivious to GBVF in the country.
Within the, sorry to interject, within the context of the statistics that I'm referring to, which you are not aware and up until you were in Parliament.
I was aware that there are high numbers of GBVF cases across the board because it is publicly published and talked about. I became keenly aware of our failure as the NPA in dealing with GBVF in a specific area for a specific time because it was raised where I was. That it doesn't take away that I was aware that GBVF is an issue. I was also aware that there are high-profile matters within the NPA. I do follow in terms of the serial rapist matters, matters that affect children, child rape matters. Those I'm aware of as a citizen, but also as a prosecutor. But the numbers, I was not aware, sir, of the
maybe
numbers.
Maybe just to assist there, Mr. Mutlong, maybe I put it differently, Advocate Johnson. You're part of the management of NPA as
Correct.
a senior manager. So has NPA in its executive meetings ever considered the performance on sexual offenses, conviction, and what has been? Because listening here, it doesn't look like it has ever been. And it's one of the areas that NPA has not been doing well.
So they do provide those figures. At the majority of the time, it is presented at the NOM meeting, which is the one that is chaired by the head of the NPS. I don't attend those all the time. But when we are at EXCO, yes, there is a breakdown at every meeting of the performance of the NPA. So I was aware of the global performance and on non-performance. What I was trying to point out is the specific and how bad it was at the time that it was raised. What it didn't do, and I'm subject to correction, I cannot recall what the breakdowns would be, but I did know that we were not performing well as the NPA in sexual offences matters, but became more keenly aware when this was raised in the very specific way, Ndata Matlong, as it was in Parliament.
Thanks. Just last part of that is the Omotoso case as well.
Yes, sir.
That you were also not aware of the nub of the case itself, because that also fell outside the purview of your area of work?
No, correction. It's not that I was not aware of the NAB. That was such a widely publicized case in the country. So I was aware of the charges. I was aware that there were many charges that were facing the accused at the time. And I do know that the case took long, where I then drew an acute interest was how we lost the case. I then drew interest therein, but I was not oblivious to the case.
Yes,
there are some matters that you become aware of, sir, because, as I said, in the meeting that is chaired by the head of NPS, some of the high-profile matters are in fact mentioned. And this was a matter that took 7 or 8 years, and during the course of that time, this matter was mentioned, but not that there were challenges in the matter. At least not in a meeting where I was. Remember, sir, that those meetings that they would have about GBVF would also not be in the management meetings. There would be separate meetings with those people who deal with GBVF and or the respective DPP office.
Thank you.
Ms. Maluleka.
Thank you, Chair, and good afternoon, Advocate Johnson.
Good afternoon, ma'am.
So earlier on, you talked about an observation around morale of staff. I think your words were, you weren't going to be clear about to what extent low morale's got to do with disgruntlement and whether or not it's legitimate matters. What is the conversation that's being held at the Executive Committee or at MANCO, which I believe you're also part of, that around the morale of staff? Could you maybe give us a sense about the conversation that's being had on this very topic?
So, the main part of the conversation is had we gotten to the source of the problem? We hadn't, but we had been having conversations about how is it that we've had a changed management, that we have more resources, that we have more capacity, and that we have more training, that staff are still disgruntled. And what we sought to do in those meetings is to look at, I know they did cohesion sessions for the staff with outside parties. That feedback was brought into the fore to understand what the unhappiness was about. A lot of the unhappiness, from my own understanding and interpretation of those, has been that prosecutors feel that especially communication of management issues are not conveyed timeously when you have changes of management. People want to know, why is Andrea Johnson in that job? Were we given an opportunity? No, we were not given an opportunity. People may see that in terms of certain appointments, people are favored, and they make their own deductions about why people might be favored. And so those are long-standing issues. And I think one of the most important things is something Minister has done, and if Minister will allow me to allude to it, it's become very important in how we do our appointments, especially of senior management, because the appointment of senior management talks to transparency and it talks to credibility. And that the NPA, that has been the biggest gripe. People on the ground want to know how senior managers are appointed. As the panel would know, most, if not all, from the DPPs to the SDPPs, DNDPPs, are appointed, Minister, you'll forgive my wording, at the behest of a national director. These people do not attend interviews, etc. That is the core gripe, Maluleka, of the staff. And the one thing Minister has made very clear is that must change. Also how we recruit internally. The panel cannot only consist of internal people. We must have someone from outside. It brings an independent mind to bear. It also brings a sense of comfort and confidence to those NPA officials that are applying for the post. The majority of it is within the recruitment. Secondly, it is the morale talks to the training. Unfortunately, when training initiatives are presented, not everyone is available. You end up finding that the same person goes to 2 or 3 training ventures for that year, And then that in itself causes a lot of dissatisfaction. But the majority of it has been how appointments have been made and the transparency with appointments, because people want to know and they have every right to know.
So earlier on, you talked about the organized crime strategy, right? That had been the outcome of a consultative process with other institutions. And it was approved, I think you said late 2024. What's the status of its implementation as things stand, and what is the current conversation about it at EXCO?
So the organized crime strategy became actionable from the date of the signature. So I cannot remember the exact date, but in 2024 when it was signed. What that has done is it has made, there's a different engagement with prosecutors on the ground. So organized crime prosecutors always formed part of a component, and they just dealt with the matters as they came in. What now happens is, if you take a division, the DPP gets to understand at a higher level what the organized crime priorities are. And the DPP has to then ensure that they have dedicated staff to deal with those priorities, and also what the engagements must be with the stakeholders, who the relevant stakeholders are, and what will drive the identification, investigation, and prosecution of those matters. They are happening in all of the organized crime components as they are across the country. And then there is a lot of engagement with the organized crime component that sits at head office in terms of mentoring and in terms of ensuring that the plan is implemented and that the partners still remain on track, especially the DPCI, because the organized crime, Maluleke, that we talk about is the higher levels of organized crime dealt with by the DPCI. And what the NPA also does is there's an active engagement in the projects committee in the divisions, provinces, they're called provincial project committees, and then the national projects committee of the DPCI, where the NPA also sits. Projects are then presented, and they then get to decide in terms of priorities as a law enforcement group, together with asset forfeiture. I believe the South African Revenue Services sit there, the FIC, as well as the SIU are also in attendance. So the approach is holistic, and the partners, together with the NPA, drive the priorities and the crime types that are identified. So it is being implemented.
Thank you, Minister. Advocate Johnson, I just wanted to ride on Professor Fikeni's comment. This one is a comment just to say, I'm a bit concerned about your level of vigilance, because one would expect it to be much higher than an ordinary person. Not belaboring the issue of the deductions that started in 2000. They're going for 20, I don't know what years now, 26, 25 years. And that is worrying to me, because that has got an impact on who you are in the eyes of certain people inside. That's one of the many reasons. But secondly, I also, why I had to bring it back, the issue of referees, I would expect somebody who has got a friend who is maybe a scientist or something to say they were acting as a judge and write that, not you and me.
Correct.
We are lawyers.
Correct.
And it's worrying me that we had to pick it up here. You know how judges act. This person is a magistrate.
Correct.
You have written a senior judge. It's almost, it's bordering, if not full-blown, misleading. Because if some of the panel members or all of us did not know what an acting judge is, it gives it a different turn altogether. One of your referees is an acting judge.
Correct. As
opposed to a magistrate. Those things worry me. They're small, but they worry me. A third one is the Estina matter was also thrown out of court as a result of unreasonable delays. And you have not mentioned it. You know, so that's how I say maybe it's just comments, but unreasonable delays in the courts is fundamental because it goes to the heart of justice and a fair trial and access to the courts and therefore access to justice. You know, so it's worrying me that the way you look at things or the way you couch them, it's a different certain level of a truth as you see it, but not necessarily an absolute truth. I think I'm also trying to be strategic.
No,
but you hear me.
No, I hear you.
It's already 3 examples.
Yes.
Wherein, at the end of the day, you have not been entirely truthful. Let me just put it out there.
Absolutely, and I want to be very clear. I have not been dishonest.
Okay.
I honestly overlooked those referees. I honestly did. Because at the time when I received the call, I sent my CV. You have no reason not to say I have to be even more vigilant. And in Estina, I didn't hide anything. Part of the unreasonable delays was the disclosure. I talked to what the court found about why that matter was struck off the roll. So please do not see the response as being dishonest. I responded as I do because I took the points that I saw. At no stage is it ever my intent. If that is the impression that was created, I can't fault me for making the deduction that you do. It was never the intention.
Should we then conclude that, maybe the mic there? Should we then conclude that your ability to pay attention to detail is a bit of an issue? Let me tell you why. Let me give her the CV. Your CV is full of flaws. There's inconsistency between your CV and the form that we've sent you.
Sure.
And that is worrying for me. I just looked at it. If we go to your CV, and because you work with me, you know me by now that I do pay attention to details. Look at the position you're saying there. Page 4 is fine. It's Investigative Directorate 1 March 2022 to date. You go to the next one. Company section, DPP Pretoria, Senior Deputy Director Public Prosecution, February 2012 to date. You go previous employer, company, Department of Justice, Section Magistrate Court. Next one, prosecutor, 1996-1998.
Yes. At the time, it was the Department of Justice.
But the years are not correlating. Oh, yeah, that one is fine.
Yes.
Oh, that one is fine. It's the other one that I picked up. And then you go to 98 to 99.
Yes.
That's what you had corrected on the form. Go to the next one, and then 1999 to 2004. That one is fine. 2004. I'll show you the other one that has a problem. Because I've been corresponding with this one. Check on the one of...
On page 8.
On page 8 as well.
Correct.
There's a problem there. The next page as well, let me just show you.
The dates.
Employment period is a problem as well. The next page as well, 6 February 2019 to date, a problem again.
To date, yes.
So you see what I'm raising. Again, you go back to page 11, National Coordinator Organized Crime, 2019 to date. This is your CV. Now, your CV is meant for us to be able to use as a determining process as well. So that's why I would correspond between the CV
and the question
form. And that's what I'm saying. If you're saying that it was not misleading, then I conclude that you do not pay attention to detail.
In this instance, I didn't. I clearly didn't. Unintentionally, I didn't. I really sent my CV. And if you'll allow me, Minister, There can be no excuses, but I'd like you to hear the following. I don't apply for jobs. It's not something I do. But I take the point that I'm supposed to be more vigilant with the CV. I sent my CV, and I accept that I was wrong. I should have checked it first and then sent it. That is why when I had to do the questionnaire myself, I was vigilant in the questionnaire and was able to properly set out, because that was then the document I was penning myself. But
No,
I can't argue from the point.
Advocate, I hear you are taking it, and I think this is just beyond here. Because we published this thing, this CV, before we could get the form. We've never published the form. We took your CV and published it.
I accept that.
The team emailed you to say, please verify this CV because we are going to publish it. Because I asked them to get permission from all of you before we could publish the CVs, so that you are not found wanting. Anything that you are not comfortable about, please take it out. This is what you sent us. And that's what I'm saying. My issue is the ability to pay attention to detail. It's the membership of the union. You didn't pay attention to detail. It's the CV. It has for a prosecutor, senior prosecutor, and a head of an investigating directorate that has the work that you carry a huge weight in your shoulders, not to be able to pay attention to detail.
I know that, yes, here you are correct. I really am vigilant. When it comes to my work, I really am. Here, I can't take away that I didn't pay attention to my CV. I really didn't. And I don't have excuses to make. There's none to be made. Even on the item that Prof raised. It's been there. If it's to be corrected, I will correct it. It's been going off my salary. There's nothing to hide, panelists. It is as I answered.
Minister, yeah, I was going to say, for a member of the public out there who would say, since 2001, there is a small amount that is being deducted. How do you know that there isn't a 100 rand that is being deposited by some shady person who tomorrow can turn around and say, please, you do know me, check your bank statements?
So in terms of my bank account, the difference is getting those notifications. I get the notifications and I do check my bank account. This goes off my salary advice. That membership goes off as a stop order. That is what we were expected to put in those many years ago, May. So those go off differently. They don't go off my bank account. They get withdrawn before you get your salary. So I'm saying it is there because it's always been there, but not in my bank account. I am clear about what's in my bank account.
Thank you, Chairperson. Good afternoon again, ma'am. I don't want to flog a dead horse, but if you do send out your CV, you contact the person who's your referee to say, listen, I've sent you my CV. Somebody may call you and to tell you that, that you are my referee. So again, attention to detail and to be vigilant, because this is normally what happens. But I want to follow up on my colleague, the AG's, the issue about the morale. And you have explained in detail, how to work with people in terms of understanding the strength and the weaknesses, and also to be inclusive and have that leadership style and so on. But the fact that you talk about the morale and then explain about people, wanting to know who's getting what and what positions and so on. Two questions. Does it mean that the morale is so low in the organization, as a whole, all its business units, and that affects the output and the productivity and the output that creates the kind of problems that we see, that you yourself have identified? So people will say, the morale is low, we don't know what's happening, why must I do all my work and so on? So should you be successful, what is it that you're going to change, apart from the stuff that you say, that how you need to engage, understand, and hear what people are saying. But the point is that if an organization's morale is low, the staff are quote, concerned, it does affect their work and the quality of their work and what work they put out. And does that not then constitute an injustice to the people that you serve and have to defend? Thank you.
So if so over and beyond the other issues that I raised, Mr. Nissen, about the appointments, etc., and the training, what has also become very important is people want to understand what the strategic vision is of the NPA. And I think that what happens on a higher level, managers know it. And I don't know that they communicate it as widely as they should. So people see themselves as, I've just got to do this work. I hear this is a priority, this is the priority I have to do. So what a national director has to do is ensure that the management, which are the DPPs, the special directors, chief prosecutors, and senior public prosecutors, engage with prosecutors every single month. They must be able to meet with them. They must be able to tell them what the objectives are, what their commitments are for that month, hear what the challenges are in achieving the convictions and ensuring that matters are not withdrawn. What do those prosecutors need? It is engagement and communication. And I think it sounds simplistic, sir, but if you engage and you communicate, people tend to understand and have ownership. And when you have ownership, you are able to perform differently. It will also go back to the question that Prof had raised, targets versus impact. When people understand the true impact of corruption, organized crime, GBVF, that it's not about achieving numbers, this is how we make impact, then people operate and perform differently. It's really the communication of what we want and the why. And it has to be done on a continuous cycle. It's in that, if you'd allow me, that you get to understand what the shortcomings are of your own prosecutors, not just it's a morale issue. People may want to perform. People don't also necessarily tell you, Mr. Nissen, that I need more training. But when you engage more, you get to understand. And I think all of those will talk to how we then perform, because the morale becomes a positive as opposed to a negative. At least that is how I see it.
Advocate Johnson, I wanted to take you back just 1 or 2 steps. Nothing hopefully too hectic. 2 steps. Nothing hopefully too hectic.
Coming from you.
Yeah, coming from me.
No, I sorry. You know, sorry,
okay.
Minister. He smiles, and then when he asks the question, it doesn't leave you smiling. So I say in jest. Sorry, sir, I interrupted
It's okay.
you.
Maybe that's the whole point of making everybody comfortable, so that we don't have to look at this process as if it's an interrogation room. It's not. So, and that's what the minister encouraged us to do, not to deal with colleagues as if we are in an interrogation, sir. I wanted to check with you, when you talk about the consequence management scenarios, I want you to cast your mind back from all the responsibilities you had to carry in the NPA. IDEC, you started leading it 2 years ago. I think it has 2 years since then, if I understood you correctly. Then you calculate the number of years that you served in senior management in the NPA. My imagination tells me that you have been in senior management for the longest time to be able to be part of that communication that you are currently talking to. And my understanding says the current incumbent has been in the institution for at least 6 to 7 years at most, and you have been there throughout. She actually found you there, and that's how I understand you. Now, having been part of that development of that very same first strategic plan that you guys created and developed, and even agreed about how it filters down, how you communicate it. Let me then understand from you, what became your role in that space of that communication, of that strategic plan, to filter it down to the very junior prosecutor who just entered the prosecution role in the courts? How did you assist that, or perhaps not assist that?
So at the time that I became involved, I was at head office organized crime, and that was from February 2019 till the end of February 2022.
Okay.
So part of that engagement was ensuring that in order to achieve our organized crime targets, to help prosecutors understand, especially at head office, part of the head office component's duties was to enable prosecutors to understand racketeering, what was required for racketeering, what the priorities were. So when we had the National Operations Management Meeting, which is the management meeting of the head of NPS, we would engage with the DPPs to ensure that them and their divisions understood what was required. We would also go to the divisions. I would travel, for example, to Mpumalanga twice a month. I would engage with stakeholders for the illicit mining. Another colleague would go and engage on environmental matters. I engage stakeholders in terms of serious violent crime, cash in transits, and we also then engaged with the stakeholders. When we came back, where it became necessary in terms of the achievement of the strategy, we would make sure that we wrote the necessary letters or guidance documents, criteria documents, and sent them down through the provinces, because in the provinces it is the DPPs that are in charge. However, we were allowed, and we did. I would engage with the organized crime nodal points in each division. We also had meetings to understand that they knew what we needed, to tell us what they needed, and to indicate what their challenges were. Those then got escalated higher. So there was that engagement, but only because I was at a head office level. But the DPPs, we engaged with them, and from there they engaged with their staff.
Okay. In line with that, if there was discontent amongst those staff members that you are speaking about, was the discontent at managerial level with the DPPs across the country, or was it a head office based discontent?
No, I don't know if that's the right word, but the challenges that prosecutors had.
I don't want to use the word disgruntlement because I'm not very sure where you got it. Okay. So I'm just using a simpler word that gives you opportunity to explain. When a colleague says to you, I don't understand how Mr. Nelson was appointed. That is how you want us to understand you. So I want you to understand me that way.
Understood. So when those issues were raised, especially where I had those meetings with the organized crime nodal points, we documented them, we did send them back to the DPPs, and we asked for feedback, because the head of the NPS must ensure that those challenges are actually dealt with, and they would get dealt with. The majority of the issues that were raised were issues of resource at that time. Not all prosecutors are specialist prosecutors. And so you found that those prosecutors who had to deal with organized crime invariably were in the DPP offices, and there were very small numbers of those. The majority of prosecutors were in what is called the general prosecution stream. So those prosecutors, the biggest issue was resources. The other issue that they did have is challenges with investigations, but they dealt with them then in the province. But they would escalate and indicate those. When we had the national meetings with the Hawks, we would make sure that General Labia and his team were informed of the investigative challenges that were encountered in a specific division with the organized crime component. And him and his organized crime head would then ensure that they dealt with it there.
But the point I'm trying to get from you is this disgruntlement. Let me use your own word then. Maybe it would be easier. This disgruntlement, did it exist or does it exist in your area within the 2019 up to date or until 2022, or did it exist in the general public prosecution space as you want us to understand the two separately?
It's across the board because you had resource constraints, whether it was commercial crime or corruption. We had resource constraints in the sexual offences unit. We had resource constraints as well in organized crime. So it was a generic issue of resources, and there was a generic issue of investigations, capabilities of investigators, training for prosecutors, and that was across the board. It wasn't unique to a specific unit, and that was at the time. I know now that there's more engagements between DPPs and their units. You also now have special directors in those specialist units, and the problems are escalated and dealt with there as well. It's only where a problem cannot be dealt with that it is raised with the head of the NPS, Advocate de Kock at the time, now Advocate Mzinyati, and they also do get escalated, especially resource issues to the Office Strategy, Operations and Compliance, which deals with capacitating and training. Prof?
Thank you. Thanks.
You've been with the NPA long enough to be able to characterize it. You've mainly referred to staff and prosecutors at the leadership level. Is NPA a house divided, or do you have any other type of leadership challenges? And if so, should you become the head of the institution, what would you do to cure that problem? And the second layer of that question, if you can help us lift one or two things in your long career within the institution where you say, I initiated this particular change and championed it and saw it through in terms of its implementation, and it will forever be remembered as something that I initiated. Not what the group, what the leader said should be implemented, but something that is your flagship when you reflect.
Myself.
Yes.
So on the first question, Prof, is the leadership divided? It's not divided, but even within that leadership, I think there are challenges. I think it is also borne out by the Kabinde inquiry and how it has been playing itself out. And that leadership issues are simply, again, back to appointments in the main and communication. I do sit with the DPPs and the special directors, and the biggest issue is when decisions are made in the NPA, we want to be consulted. They all want to be consulted. It shouldn't be a group that is consulted, and they feel that the consultation process isn't as wide as it should be. That is the main disgruntlement, for lack of a better description. And when people feel that not everybody is part of, not everyone can be making the decision, but they should give input into certain aspects that will affect how they operate. They want to be consulted. They do understand that there are certain instances where A person must
Can I
make
press
it.
you on that one? Do you feel like there are people who are insiders who get consulted and others who do not within the leadership?
So I have not personally experienced that, but I speak in terms of when I talk to colleagues that feel there should have been consultation. You take, for example, we had an issue, Minister might be aware of the issue with when the DPP for Johannesburg was suspended, there was a lot of issues around we are fellow DPPs. Tell us what is going on. This is a senior colleague. It can happen to us tomorrow. Now, I understand why you, on discipline issue, cannot talk to everybody, but my colleagues felt, all of us felt, at least give us a high level. What is happening? The senior colleague is suspended, and there are steps that are now going to be taken. It makes them feel disenfranchised, because all that happens is those that remain look at one another suspiciously. Did you know? Did you know? And you can't have second guessing. And that is a key issue when we are not, we have to be taken into confidence on key strategic issues. When you deal with a senior member of the NPA, it is not, oh well, Andrea Johnson is suspended. We're not going to tell you why. It cannot be. In terms of change and champion, over the years we've done things as a collective. But the two things, or the one thing, when I took office at IDEC in 1 March 2022, IDEC did not have, as we used to have in the DSO, an operations manual. An operations manual that dealt with all of the administrative duties, that dealt with the role and function of investigators, criminal and financial, and that dealt with the role of prosecutors and how matters came in, intake criteria, and the processes that were needed. I remember sitting down and I took a A3 and I started in my head to map out how we should operate. From start, when we get a matter, till we get to court. It really was an ugly handwriting drawing. I still have it. It is my pride because I penned it out of my own experience. And
through you, Chair, IDEC, because you are starting it, it's naturally going to be, we had to do the following. Like anyone starting an organization, they'll say, have A, B, C, D, E. But within the NPA, so prior to that.
Why I wouldn't, if you would allow me, why I wouldn't brush it off.
Yes.
The ID was proclaimed in April of 2019. We are talking about 2022. There wasn't such an operating document. IDEC is in the NPA. You want to deal with corruption, which is a country priority. You must have a plan. You must have a process. We did not have that. So that is a key initiative, changed and championed by myself. Penned it, and then had our management sit together so that together with our strategy management office, take them through the document, what we understood. At the end of 6 or 8 months, we have a IDEC operations manual from start to finish. It is there for every new employee that comes in. And we were the only ones, still are the only ones, that have a full operations manual from all the specialized units in the NPA. So I do take your point, Dr. Fikeni, Prof. Fikeni, but unfortunately, there wasn't anything from 2019 to 2022 March in that area where you clearly could tell the people what is expected. So as we get new employees that come in, It is part of the induction program, and they then get the training manual, which they are able to use regardless of what rank or capacity they are appointed in.
Okay, I've been asked that all of us pull the mics closer. We seem to be fading away for some reason. It's late in the day. Proceed, Ms. Morton.
Thank you, Chair. Advocate Johnson, I'm trying to figure out what would you do differently if you had to be appointed as the NDPP to ensure that you dealt with these matters around communication, as my colleague Mr. Mvundlela was exploring with you, morale, cohesion at EXCO. And I say cohesion because that you heard about the GBV matter in Parliament suggests that the critical conversations around key mandates for NPA and key priorities for NPA are not effective at the collective of leadership within the NPA. If I listen to your answer about that, your answer about the implementation of the organized crime strategy, because the question I asked was, what is the conversation about it at EXCO? So what would you do differently to ensure that you build an institution where the collective leadership works in a cohesive way towards achieving the mandate?
And that's not going to be an overnight success for anybody, not just me. And I think it is because of how the organization has to operate. It has to be operational and perform while still attending to its strategy and ensuring that the strategy is understood and implemented by everyone. And it is finding time to, so if we start at the top leadership, it is a national director with the deputy nationals. In the time that I've engaged on that platform, there is clarity amongst them on what each one's roles and responsibilities are. I think where the disconnect might be is from there to below. In terms of every deputy national should take the DPP's special directors more into their confidence on what the objectives are. Now, every deputy national deals with it, but they deal with it, the head of NPS, the head of AFU, the head of SOC. We do have a MANCO, and at that MANCO, these are also discussed. But I guess given the time when these meetings and the length of those meetings, you don't discuss all the details. And we have to find the time to make sure that the details are dealt with. A national director is responsible for all the prosecutors, processes, prosecutions, whether they're instituted and where they are stopped. The national director has to make sure that all the prosecutors, now how do you get all the prosecutors to know that these are our responsibilities? It's not just about having regular meetings with your top management. It is about going down to grassroots level. I know that our current national director had been doing that in this past year, where she's had regional visits and she's engaged more with the staff, and she wanted staff to understand there is a different level of understanding and appreciation for where we are at and what we need to do. That has to continue. But you also have to deal in terms of the staff. Staff need to know that their actions have a reputational risk to the NPA and what that reputational risk does to our performance. And we can only do that if we are talking to them through the different levels. So again, I say it sounds simple, but the communication and what is being communicated, when it is being communicated, and then holding those different levels of managers accountable. Dr. Motlong, there has to be consequences for why we don't engage our people perhaps as much as they want us to engage. What stops us from talking to our people about what needs to be achieved? Now, a national director cannot be seen to be the head of the organization divorced from his or her people. You must be able to communicate the message. So if we had to talk about the GBVF, what must a national director communicate? A national director must be able to communicate to all prosecutors, we are doing really badly. Where are we doing badly and why are we doing badly? And what is the consequence of us not doing that work? And I think when you have those kinds of communications, it affects positively all of the other levels: morale, performance, impact, and understanding why we are the NPA. It really is the communication is the golden thread through which any leader of an organization is able to reach his or her people.
Thank you, Chair. I've actually been trying to resist the temptation to venture into this question, but I think it's quite relevant that I should pose this question to you, particularly taking into account the role and mandate of IDEC. What's your view on the landmark decision of 2011, the Glenister versus the President of the Republic of South Africa? That's a preamble to a follow-up question.
When the legislation was promulgated for the creation of IDEC as a permanent body, they considered Glenister 1 and 2. We looked at the STIRS requirement to make sure that it forms part of how we're going to operate and engage.
And there has been some developments since then, and a case in point is the introduction of Constitution 21st Amendment Bill. What's your take on the proposed bill?
Is that the private members' bill?
No.
No,
the Constitution 21st Amendment Bill. That proposes the Anti-Corruption Commission.
Okay, maybe let me just help, because they don't deal with the legislation particularly. It will be in the department. So I'm not so sure if you would have seen, because it's a proposal, it's a private members bill, definitely, by DA that we responded to.
Okay, so you may not be aware of it.
I'm just aware of it as the private members bill, but as Minister says, the legislation is with the department, and where comment is required, they would have asked us.
Okay, thank you.
Thank you, Minister.
Any other question? Okay.
Thanks. Dr. Jones, Advocate Jones.
He says smilingly.
Do you share the view? I'm smiling because I called you doctor, and I was scared that you would remind me that generally in the legal field, LLD may not be something that we actually put forward much about. Not that we don't encourage people to study. Do you share the view that there is, and there may have been or could be situations where there was political interference in public prosecutions? Do you share that view? Because it does exist in society. Maybe just to give you comfort. You would not be the first one to say
no,
so.
I am aware of that view.
Okay.
I can tell you that in my time, no one has interfered, no minister, whether within the Department of Justice or elsewhere, or the President, in the work that myself or my team have done. I am aware that when we were in the DSO, there were talks that there would have been political interference. And I know that that was dealt with both in the Hefe and in the Janwala commissions. And that's the extent of it. But in the actual operational work, there are allegations of political interference in state capture matters. But in the matters that we've done to date, there hasn't been political interference on that, where you can say, it is Minister so-and-so, it is this political person, etc. What we do have that is different is you have in the group of criminality politically exposed persons against whom allegations of crime are being investigated and made. So I am aware of what you say, but I have not experienced it, nor has anyone in my field where I currently am or where I've come from in terms of organized crime.
Great. Now, with that in mind, possible elevation to the National Director of Public Prosecutions. And perception in South Africa has become a norm. You know, anybody can say anything and then everybody believes it, in whatever form that it is said. How do you see yourself managing that possible perception, at least for the benefit of the NPA's reputation? Because that is what this country needs. An NPA with a reputation that is beyond reproach. How do you see yourself playing a role in that space?
I think maybe because of the kind of cases we've had to do and the work that I've had to engage in, it's been easy to deal with the work. And when you deal with the work, when you deal with the evidence and the law, there is no room for somebody to come in. You do not allow for somebody to come in. And the very first time that that happens, you've got to escalate it. It doesn't matter what the rank of that person is. And if there's a fear that if you escalate it within your structures to which the NPA reports, then you have to find a way to ensure that that interference is brought to the fore. But you cannot, I have no intention that if somebody says, sorry, Johnson, those cases, why aren't they being dealt with? Unless there's a public interest and a member of public may have raised that through a specific individual, that individual must put in writing what are they asking of the national director so that the national director is able to deal with the public interest issue of whether or not something was done in the NPA. But where there is actual interference, you have to deal with it the very first time. Even if it is not overt, and there's someone is suggestive in the way they approach you, and they are of that position, you have to deal with it. We have a minister. I'm not sure how long. My minister is my minister. In this administration, this is my minister. And our minister has never once, and I'm happy to say that, and she can leave the room if she's uncomfortable and then she'll come back because I'm talking about her. But this minister has not asked, even of IDEC, which has such highly controversial matters where there are politically exposed persons. This minister has not asked of the ID and anyone in her staff, why did you enroll that matter and not that matter? The only thing we have had to do, not with this minister, but any other minister in the NPA, in the work that I have done, they are entitled to ask for a Section 33 report, which is a very high-level report. But that is as far as the reporting or what are you doing. But the what are you doing talks more to not why you're not charging this person or why have you charged this person. It's can you account for the work. I am the overall counter of your work to Parliament. I'm not happy. Account. And that is the only accounting that we've been asked to do that I am aware of.
Thank you, Minister. That's all.
I think it would be a rider to this question in a hypothetical, probably projected situation. Where the Truth and Reconciliation case is loading, Zondo Commission case is loading, current cases of the Madlanga Commission loading, it stands to reason that political pressure and appetite to interfere may happen. It also stands to reason that with the turnover of ministers, it may not just be a person. How would you institutionalize insulation of your work irrespective of who is there?
The only way I know how to deal with it, Prof, is you have to stick to your strategic plan, you have to stick to the mandate, and you have to ensure that the work that we do is in terms, and I've said it before, and I'm sorry if it sounds like a repeat, the work we do must be evidence and law-based. When you do that, it is very difficult for somebody to compromise your work. We must also be open to review of our work. I think that that is the one thing that we don't do as well as we should. We must be able to account to the public. Perhaps every quarter we should have a state of prosecution report. Tell them where we are as the National Prosecuting Authority. What were we intending to achieve in that quarter? Why haven't we achieved it? When you start talking to the public sentiment changes. And when public sentiment changes, the room for someone wanting to interfere is curtailed because they know you will go out there. And when you tell your story, you'll have to tell that part of the story.
Any other question? We're done. We move to the next one. You want to?
Yeah, no, we can move.
Okay. Let me hand over to Mr. Mutlu to take us through the public comments. You would have seen them, and we would have given you an opportunity to respond, but he will take you through.
Thank you, Minister. Advocate Johnson, as Minister when she introduced the flow of the process, intimated that we have received a high number of public comments. And it's on record that we received a whopping 209 comments. And out of the 209 comments received, only one supported your appointment. So essentially, we're sitting with 208 objections. And now, I would like to take you through a whole range of these comments. But obviously, I wouldn't go through each and every comment. So I'll package these comments in terms of their similarities in content. The bulk of the comments which raised objections to your appointment has to do with conflict of interest, ethical concerns, and this stem from your recent participation in the ad hoc committee. But I'll deal with those. But there was also other comments separate from this, and I'll also deal with those comments. And they touch on issues of poor judgment, but also ethical concerns in how you dealt with some of the cases that they have listed. So perhaps it would be prudent that I should take you through the comment that deals with your support of your appointment and just take it out of the way. And this It's a comment that was received. It's under 190. You should have received it. Column 190. And this comment comes from Robert Mailula, who says Advocate Johnson leads the investigative directorate and has long-standing experience in organized crime and corruption cases. Her Scorpion-era background shows a strong commitment in accountability and results. Her strengths are skilled in handling high-level corruption, strong operational knowledge of the NPA, and respected within prosecutorial cycles. So this is the support that you receive. But then, if I can take you to a comment on column 10. You should have received it as well. And you had the opportunity to respond to it. This comment says, Advocate Andrea Johnson has been compromised and cannot be trusted with such a high-profile office in our justice system. I recommend that she's removed from the shortlist. And there's a comment from on column number 19, which just sums up as well how the public felt about your candidature. I register my objection to the consideration and possible shortlisting of Advocate Andrea Johnson for the position of National Director of Public Prosecution, South Africa. Or South Africa not risk appointing an NDPP whose ethical record, actions and conduct have already been publicly questioned and criticized, including by the Matlanga Commission, which highlighted serious concerns about governance failures, conflict of interest, and compromised decision-making within NPA's leadership structures. Some of these revelations involves or implicate the leadership environment in which Advocate Johnson operated. So this is part of the comments that I needed to highlight to you. So this has to do with, among others, your admission to have been involved in the selection and recruitment process involving your husband, which you admitted at the recent ad hoc committee sessions. Now, there is also a comment which you are aware of, and this comment is from Mr. Matsela Koko, who raised an objection. And for the sake of transparency, I will read the contents of.
Also, do you indicate that he didn't indicate that he's got a case that is in IDEC as he did the objection?
Indeed, he didn't mention that, and the objection also is unrelated in as far as this case, that the pending case is concerned. Dear members of the NDPP selection panel, I'm writing to formally submit my objection for the consideration of Advocate Andrea Johnson for the position of National Director of Public Prosecutions, NDPP. As a former ESCOM Group Executive, directly impacted by the matters outlined in my submissions, I believe her actions in relation to the 2022 Alternative Dispute Resolution and Cooperation Agreement with ABB South Africa Pty Ltd render her unfit for this critical role under Section 9(1) of the National Prosecuting Authority Act 32 of 1998. Please find attached my detailed submission titled The Constitutional Disqualification of Advocate Andrea Johnson for the position of National Director of Public Prosecution, which sets out the constitutional, policy, and evidentiary grounds for the objection. For your reference, the submission includes the following supporting attachments. Well and Sonntag article dated 16 November 2025. 2. The Nkabinde Commission transcript excerpts from Advocate Shamila Batohi testimony, 27 November 2025. High Court of Canton of Zurich judgment, which is translated. This judgment was given out on the 20th of November 2024. DCP Directive, ADRCA, Constitutional Review, Gauteng Division, Pretoria, set down for April 2026. I'm available to provide further information or clarification if required. By contact details are provided below. And as you would be aware, the attachment that is referred to has to do with an agreement between this company that is referred to, the ABB South Africa, and this was an agreement for payment of an amount of 2.5 billion in exchange of indemnity to prosecute on crimes related to breaker and poker, among others. There is also an objection that was posted on Facebook, where the author indicated that you should be stopped from being appointed as a director of National Director of Public Prosecutions.
Verify Facebook linked to DOJ as a submission.
Indeed, Minister. This you would also locate under an attachment PCJ 3 that you would have received. South Africa cannot risk an ethically compromised NDPP. There was also an attachment referred to as PCJ1, which...
PCJ1?
Yes.
Can I request that we do not process that here?
Yes. Oh,
I've
okay.
been alerted, that's what will be on my desk. It relates to decision of prosecution and perhaps having to inquire of her fitness to hold office. Advocate, I just became aware it's the one that relates to a decision on the Mapisa Ngakula case, and that the team jeopardized Nombasando Zondwa Ndlovu's own prosecution. So the issue is on how the prosecution process has been handled in a court. I hope I'm clear on that one. My voice seems to be going. I don't know what's happening with it. So that PCJ, that's what I'm picking up. It's more on cases that are running.
That are live in court, yes.
Yeah, that are live in court. So I'm going to request that we do not deal with those.
Thank you, Minister. So, Advocate Johnson, these are the objections received from the public, which obviously you were afforded the opportunity to respond to such. So these objections were made. You were made aware of the contents of the objections, and you were given the opportunity to respond. Now, for the sake of brevity and transparency, it would then be prudent of us in this process to allow the opportunity to place on record your response to these objections, and so I can afford you that opportunity to do so.
Maybe before you omitted the Daily Maverick one, because I do think as much as the support, there's issues that they're raising. Should I do it?
Thank you, Minister. That's the first one, actually.
Is it? Oh, okay.
Yes.
Yeah.
Yes,
But I
that's the
didn't
first
hear
one.
you.
You can do it. Yes.
Can I do it? Yeah.
Yes.
Daily Maverick makes a comment here. Johnson has a reputation as an excellent prosecutor. She has set up the investigating directorate against corruption. She's the best chance SA has of fighting organized crime and corruption. She's the most experienced prosecutor in the field. Her appearance before Parliament's ad hoc inquiry into Mkhwana's allegation did not go well, and this could be a markdown for her. Johnson has temperament for the role and is fearless, but her management smarts are not great, and she would need support, says insiders who support her. So I would want you to also reflect. So there is an issue around your management skills from your peers as they reflect.
If I could start, would you allow me to start anywhere, or must I start at the start?
Anyway.
So just to be clear, Minister and members of the panel, the objection raised by Mr. Koko, I'm not prepared to discuss. It is currently litigated. All of the documents that he has attached as part of his objection, Minister and members, is part of court papers. It is part of a motion application.
I think I can rule that we leave it there.
Yes.
I might have missed it like the other ones. That
No, and it is understood. The state is opposing it. Just for the record, we have filed all of our papers. All of the necessary parties have filed in that Motlong. So I cannot discuss that matter.
You can move on to the next one.
Thank you.
Thank you.
If I could deal with, in the Daily Maverick, we talk of the Mkhwanazi allegations and what happened at ad hoc. Minister, I made it clear when I was at ad hoc, I didn't understand the 6th July media briefing. It had taken me by surprise, as I testified, simply because General Mkhwanazi and myself in particular had worked well over the years and had not had any disagreements either about what each was doing or what we did collectively. I had to respect the process. I said at the ad hoc committee that once I'm done testifying, I will in fact call the general, because I need to understand we are both still in our spheres of work. The work doesn't stop while ad hoc and Madlanga carry on. I in fact did call General Mkhwanazi, perhaps 2 weeks after my testimony at the ad hoc was done. The gist of the conversation that the Motlong was, General, I told the committee I will call you. I'm calling you to understand where did we go wrong. I didn't understand that we had a challenge. And if there's something I was not aware of, please tell me. And I want to set the record straight. It is telephonic, but we should have a meeting. Said, I want to be very clear, as I was at ad hoc. The only matter, you talk of a big five. I don't know your big five. I also do not know the organized crime the so-called big five are involved in. The only matter we have where there is...
Johnson, I'm going to ask you deal with what we're dealing with. I don't want to get into the Madlanga and ad hoc committee space.
It was just
I
the
think what they
Mkhwanazi
have-
allegation
let me-
as
let me
per the
ha- no,
Maverick.
no, let me help you. What the objection or the comment is about is that the objections are mainly about your role in relation to the appointment of your husband.
And I will deal with
Yeah,
that.
and the performance, don't go into detail about
Okay.
those investigations because we don't want to overreach
Yes.
our responsibilities. And lastly, because they just made a reference to the committee, how you performed. That committee, I think the comment from Daily Maverick says it was your law. I think they put it in that way, your law. So deal with that. Don't go into the detail of what your statement in Parliament would have been and all that, because I don't want to have a situation whereby we start wanting to correspond what you had said and all that.
Understood.
Yeah, deal with the interview, not the investigation into the allegations said by General Mkhwanazi.
So without the detail, just for the committee to know that work continues and that in terms of a conflict with regards what was raised in the Daily Maverick about the ID and or investigations being compromised, those have been dealt with. But the comment that is made there, Minister, about my performance at ad hoc, I answered to the best of my ability. It will not find favor with everyone. I could only be honest in my submissions, and I accept that. I will take the criticism that comes. And for me, I could only answer as I was asked. There's nothing different that I would say today if I was asked the same questions. When it comes to the main complaint, Ndate Motlong, as I saw it, the majority of it, when it relates to the conflict of interest, ethical leadership, I'll ask the panel and Minister to bear with me. I said, and I have to repeat, and I repeat only because I had nothing to hide. When the question was posed to me, I didn't flounder and fluster. I heard the question, and I was able to respond and say as I did, because I have no different answer. In 2007, I formed part of a panel. I cannot remember the rest of the panelists. What I did do in 2007, I did disclose that I was married and to whom I was married. And I did physically recuse myself from the shortlisting, where he was shortlisted, the actual interview, and the actual adjudication. And that was in 2007. 17 or so more years later, when it is raised, that is the only truth I have. But what it means is that I had to reflect, which is what we have to do, about the perceptions out there about whether or not my disclosing and my recusing myself from the process when he was in the interview is sufficient. And all I'm saying is, I accept that maybe what I should have done back in 2007 was recuse myself completely. It was a misjudgment. I had no intention to misrepresent anything because I did not misrepresent. I did disclose. I did recuse. It goes back to the question you raise of the standard and duty of care. And I'm saying, in hindsight, Ndate Motlong, I accept. I could have done better and I could have done differently. As a national director, given that at that time, those were the two things I knew I had to do, which was disclose and recuse. I am saying we should have more clarity in terms of a code where we must have express written declarations of ethical conflict of interest. We must all be held to that, and that must be adjudicated by an independent panel, which can also consist of outsiders. So I am saying I accept. How it looks is not good. I cannot change what I did. I have to accept that. I accepted it at the ad hoc. I accept it here. In hindsight, I should have completely removed myself and not just when he went for the interview, the shortlist, and the adjudication. If you'll allow me, I just want to check. I think
Check on
everything.
that one. Was DSO under Public Service and Administration? Was
We
it
were-
the recruitment? Were you under?
We were in the NPA, and it was NPA Act appointments.
Okay, those ones.
Those
your
ones,
husband
yes.
was under NPA Act,
Yes.
not under Public Service
No.
because it's dual.
No.
Okay.
I think all of the rest that are long flow from there. Questions about ethical leadership, etc. I have always prided myself, and I think it also talks to what was said in the Daily Maverick article and in the positive article you read. That is how I have conducted myself. This was an error of judgment. I'm not going to change it. I can't take it away. This panel will have to judge me on my entire performance, my history in the NPA, where I have faltered. And if this panel feels that in terms of that happened in 2007, where I did what I knew I was supposed to do, but when we fast forward, in hindsight, you should do differently, I can't take it further. I really can't take it further. And if I am to be penalized on a misjudgment made then, it is the penalty I have to live with. And all that you do is you say, because of that misjudgment, you will never be allowed, as you have in the rest of your unblemished career, to be able to move ahead. And I accept that. I came here knowing that those were the questions. I came here knowing that South Africa expects me to be different. I have always carried myself in a very particular way. And you can talk to stakeholders and colleagues, etc., across the board. I have a way that I have conducted myself. If I am to be penalized on this, I am where I am. And don't smile. No, I am where I am. Sorry, Minister. It is where it is. He was trying not to smile.
Okay. What level was he? Which
honestly-
area? What was he appointed for? What was the position?
At the time, it was for a special investigator or
the
a
special
senior special
investigators.
investigator. I honestly cannot recall all of the details, and everything I give you is what I have from memory. The chair, unfortunately, has passed, or else that would have assisted me, because I can't remember anyone else, Minister, that was on the panel who'd be able to say what documentation I filled in as part of my disclosure, and to corroborate that, in fact, I was not in that adjudication process, I wasn't in the shortlisting, and that I had physically recused myself and wasn't even in the vicinity when he did the interview. You only have my word.
Did he declare?
Yes, he did.
He did. Because remember, as the investigators, there's a vetting process.
Yes, he did declare.
So the vetting didn't pick up that you were sitting in the panel in the process and you had to step out. Because you sat in the process, so vetting should have been done before his appointment.
Minister-
because the Act requires vetting process.
Sorry. Yes,
That's what I was asking.
Okay.
At which Act was he appointed, knowing that NPA has two elements of it. It's got the Public Service Administration, which all the appointments that are in that side are governed by Public Service Act. And then it's got the prosecutors and investigators that are governed by, the appointments are governed by NPA Act. And the specific processes that must be done. So that's why I'm checking. And it could be not a fault of the two of you, but the person was responsible for the recruitment or overall in terms of a final approval, because the vetting is required by law. So at that point, no one raised anything,
Not at all. And
neither
just-
to you, neither to him.
Not at all. And just to be clear, Minister, from that date, this was the first time anything was raised at the ad hoc.
Okay.
I just wanted to clarify. I cannot tell you why it wasn't, and that is why I'm saying that the travesty of this situation is the chair has passed, and the chair would have been the person who signed off and would at least have been able to indicate what documentation we filled in with regards the disclosures of the relationship and or otherwise.
Okay, colleagues wanted to do a follow-up. I just wanted to clear that one. I was checking. You were still on the floor. Okay, you are doing your questionnaire, but I think everybody wants to do a follow-up on this one.
They can.
Prof, and then we will come.
Just two things. In such an illustrious career, and this blemish must have been very traumatic to you.
Yes.
And it surely must have helped you to try and retrace your steps back to that moment. I'm struggling with you saying you can't remember the details, because in a career that is unblemished, when something happens, you normally want to go back and reconstruct
Yes.
that moment. And also your husband is there to say, can you remind me on some of these and so forth. That you can't recall, it's a bit of a challenge for me. The second one, with the help of hindsight maybe, let's assume you are the successful candidate for the NPA. Would you allow, even if there were no specific laws, anyone to sit, help even in the crafting of the specification, shortlisting, adverts of a person who is a close relative of theirs, mother to child or a spouse, a cousin and so forth? How would you approach that? It's an ethical issue. Sometimes it doesn't have to be regulated by law. It's a matter of what you think is right, what you think is wrong in terms of judgment.
Just to add, Advocate Johnson, on this, I also am finding it difficult to understand how you are not able to remember the panel, and the only other panel member is the chair that you remember, and unfortunately the chair has died. That is worrying, you know. And why it's worrying? It's not that one can prove right or wrong. It's exactly what we were talking about earlier, where as a result of some of the gray areas that were allowed, that you have overlooked, where your judgment seems to have been found wanting, it almost like falls inside that pot. I guess it's a comment, but I just want you to take it with you and reflect. It does bring about doubt, you know, yeah. And then on the issue again, in your response, you said, to be clear, there were many processes that I would have had to follow thereafter before the appointment. At no stage was I questioned or informed that there was anything in which clarity was sought. This response to me also adds to the, it's almost like still not seeing anything wrong. I know you have said I should have approached it differently. I could have. Your words are I could have, not should have, which in itself is worrying. Could have is a choice. Should have is I had no choice. I had no business doing that. You know, I shouldn't have done it. And this is what is still worrying me, that the hindsight is still, but no, man, it's not that bad after all. Kind of, it gives that feeling, that sense, because of choice of words. But even here, when you say many processes, just on the many processes, if you could tell us what those processes were that followed afterwards, and wherein no one asked, who should have asked and did not ask. Thanks.
So if I take your comment, Mayor, and the question together with Prof's, I cannot recall who everybody was on the panel. It was 2007, and I don't have the documentation. And what I said was, it was the first time from 2007, now in November 2025, when the issue was raised. I go only on the memory that I have and my discussions with my husband, because he does recall that I wasn't there. He does recall he disclosed. And I said to him, yes, I also disclosed. The point is, it wasn't even a secret, but we both disclosed. It was known that we were married at the time. I don't want Mayor I understand the could have and should have. Please do not make a mistake. I am not by any means minimizing what happened then. What I'm saying is, in hindsight, it should never have happened. I should have removed myself. Sorry if I used the word could have. I'm saying, that's what I meant. I should never have done that to myself. Because look at where we are sitting 17 years later. That's what I'm saying to you. I should not have been in that situation. That is what I'm saying. And it is unfortunate. I don't have anything to refresh my memory. I really don't. And there's a reason why I remember the chair. It is because the person passed away not so long ago. And when this issue came up, I remembered, wait, because I know where that position was that he had applied for, that was the chair. He was the chair in most of the positions because it was a specific unit, and that's how I remembered the chair. I know there would have had to be another panelist, and on that I go on how we operated in terms of panelists, and there would have had to have been an HR representative. And when I talk, Mayor, of those processes, I talk from my general understanding and recollection at the time. You have the interviews, the chair would have signed off, and it would have gone into HR and those processes. And then it would have gone above that for the appointment to be signed. And that is what I mean, is I don't know who in terms of actual individuals it went to. I talk of the process it would have followed as other processes in the DSO followed where I had been a member of a panel. That is what I'm talking about. So that is how I recall it, not that actual process. And then,
Minister, can I just ask for clarity?
Okay. I have one more question.
Okay.
We can do this, Minister. If it is follow-up to that question, let me deal with it, and then I'll deal with the second question that Prof raised.
So, sorry, Minister, about that.
No, I didn't want to disturb the train of thoughts as well.
Okay.
Because on that, I thought you were coming with another one.
No. Let me just go straight to the point. Yet you had been sitting with this panel the whole time and recused yourself when Mr. Johnson came in. Is this what you're saying? You'd been sitting with them, interviewing other people, then candidate number 6, Mr. Johnson, guys, this is my husband. You walk away.
No, not at all.
Okay, all right.
Not at all.
Okay.
The panel said to me, we'll deal with the candidates. We dealt with the candidates. The panel said to me that they are now going to call Mr. Johnson. I had left the room. He came in, would have gone for his interview, and they then messaged me to come back. When I came back, he was gone.
The question is, because it's the advert, this is the post.
Yes.
So were you interviewing other candidates who were part of the interview panel of the other candidates who competed for the same position as Mr. Johnson?
Correct.
That's what she's asking.
Oh, sorry, Madam.
So
that is correct.
You actually sat through the process, but recused yourself when Mr. Johnson was to come in as part of the interview. During his interview, you were outside. You were not part of the process.
No.
You didn't interview him. But at the time he was finished, you came back to be part of the process, almost concluding the interviews, let's say, and also the deliberation that eventually made a recommendation.
So when
Can I write on that one, Chair?
maybe if I answer, then Prof will see if you want to write on it. Okay.
I just want to check, were you part of the process of conceptualizing the position?
Not at all.
Specifications?
No.
Adverts?
No.
And then sitting in the other interviews?
On all of the first mentioned, no. I was not part of conceptualizing, not part of the advert process, not part of the other aspect you raised. But I did interview other candidates who were shortlisted for that post.
And this was a position under your unit, right?
Not my unit. It was in the DSO in a different unit.
Okay, thank you.
To the question, Minister, when I had come back, so how it worked is, I can take it from what happened with the other candidates when I was in the room. As each candidate finished, we scored the candidate. The deliberations would take place once all the scoring was done. When I came back in, he had been scored by the panel that interviewed him minus me. When they did the deliberations, we deliberated on the candidates. I was part of the process. I knew his score, but I was not part of the discussion. At that time, I was now gone. That was the end of the process. So when he was recommended, I did come to know that he was recommended, because what happens, Chair, is what happens, Minister, is the Chair must send the recommendations for every panelist to sign. That we all had to sign. And that is where I saw that he was recommended by their deliberations. But I was part of deliberations of other candidates. I was part of scoring of other candidates.
And you signed the form?
I would have signed the form. What I'm saying is, I look at
so
other processes.
Else was scored by all the panels?
Yes.
Including yourself?
Yes.
And then let's say it's 6 panel members. And then at the time, how many were they?
You see, Minister, I don't know if there were,
okay,
we were 4.
I'm just going to assume.
And
say it's 4 people.
I don't know if I was replaced. I wanted to get there. I don't know if I was replaced, who I was replaced by. I left.
But Advocate Johnson, let's take it you are a manager now.
Yes.
And when an appointment is to be done, for example, at those levels, like you were explaining, that we had to introduce, for example, an external observer so that there's transparency and all that. But when you have a panel, you can't say in the middle of a panel, then you change the panel. For example, these members know that we must stick with it until the end. None of us can leave. Otherwise, they make the process irregular. Or none of them can have a replacement, because it skews the interviewing process. Because how do you determine that this person is suitable if you didn't sit in that person's interview to ask questions? We can make a reflection if we were not in the room. That's why we can't stand up, even go to the bathroom. We must sit here until we finish with you. Whether it's a question asked by this colleague or this one, we must be here to hear the responses, so that when we deliberate, we have that. So I'm trying to understand. You said it's 2007.
Yes.
It's not very long.
And unfortunately, I really cannot remember. I'm not trying to be obtuse about it.
I know I inherited the good, the bad, and the ugly as a minister. So we didn't have systems that could detect an irregularity in the process. Because that, as you are saying to me, where I'm sitting as a minister, that process was irregular.
And I accept that. And I'm saying to you, Minister, I have not been asked about this process till now in the ad hoc.
No. I'm not even worried about you now. I'm just worried about
the process.
I
then.
believe in systems.
Yes. So, and that's what I'm saying. I did at the time what I knew we were doing, was to disclose and to have recused myself. And that's all I knew that I had to do. And that is where I am.
Okay. No, understand me. I have a part. I know members are looking at a part. Because I'm a minister, I'm looking beyond just what you are saying to understand what could I be dealing with.
Yes,
beyond just you as a candidate.
But in the NPA,
because you know I'm stringent on issues of governance and processes.
Yes. So in the NPA, and I know also when we were doing interviews, especially for the advocates at the DSO, when we did them in Gauteng, we actually had a questionnaire, and we asked the same question of all candidates so that no one is prejudiced in the interview, and we did keep the same panel. In the NPA, in my years after...
No, Advocate, maybe let's tell you, those of us who specialize in corporate governance, it's not about the question, it's the entire process.
Yes.
End to end. Every step of it is critical.
Yes.
because at the point where a person is being shortlisted, remember, there will be a panel. That panel must decide on the shortlisting. A panel that shortlists can be the different panel from the one that interviews.
Correct.
You are aware of
yes,
that.
and that is the processes that we do run. So in terms of the processes in the NPA that I am a part of, even in IDEC, we first, our HR sits with us and they put together the specs for the advert.
Yes.
The advert goes through. Once that is advertised and the closing dates, all of the applications are submitted where they are submitted. They have that pre-shortlisting to see that the forms are correct, etc., and where there aren't those fall away. Then those that qualify in terms of the administrative minimum requirements are then brought through. But before we even get that, simultaneously, we have to apply for a panel approval. Depending on the level of the person, the panel could be approved in the NPA, but it's only on lower levels. The majority of our panels, especially in IDEC, for example, have come to the Office of Minister for approval. When the panel is approved, the shortlisted CVs after the pre are then brought through. First, a date is set for the shortlisting. Panel must sit together. We do deliberate, and then we indicate how many positions, what is best for so many positions. So if you have 4, it might be best to have 12 people as an example. We sit together. Once we are done with the shortlisting, we then inform HR, this is the final shortlist. We put it on a form, and there's a form all of us sign.
Yes.
Those candidates are then informed because we then, as a panel, agree to a date. That date is communicated to the potential persons that must be interviewed.
Good.
In that time, the panelists sit together, work out, but we do that so there's no compromise. On that morning, we all have to get in an hour earlier. We all sign declarations of conflict of interest, those forms, and we then work out the questions. The questions are then typed so that every candidate is asked accordingly. If there's a practical, the practical question is also done, and then the candidates come in one by one. And when they do their practical, Minister, there is always someone that is sitting with them from IDEC HR to make sure that none of the candidates talk to one another. And then when we are done, we all do sit and deliberate. The scoring is done. Sometimes we find candidates, sometimes we don't, but there is a stipulated process that we have to follow and that we do follow.
Now, explaining what you know now and the processes that you are following versus what you got involved in, what's your view?
I should not have gotten involved in it at all.
Okay.
And if there was any irregularity, I really would have appreciated at the time someone to have just raised it. And that process, Minister, if it was raised that this is irregular, I can bet you, me being me, we would have asked that it be set aside. That opportunity was not there, and I do regret. I really do regret, because here I am sitting and talking to all of you about a 2007 issue when, with everything else,
But
I'm
in
going to
law,
go.
what does that mean? There is no old case. There is no. It
Minister,
doesn't get rotten.
I leave it to you and to the panel to adjudicate, but bear in mind,
No,
Minister.
it's not for the panel.
I'm saying that bear in mind, Minister, a complaint has been raised with your office. I have to leave it to you and your discretion.
Okay. No, I just wanted so that the panel is clear.
Yes.
And I'm glad you explained from the point of, because I was worried, you leading quite a number of interview processes.
No,
I didn't want to have a sense that you are not following the process
No,
and you are not doing
we
the correct,
are, and especially
and
the
will
conflict,
have. So
conflict issues we
I'm
deal
glad
with.
that,
Yes.
Yeah, you are dealing with that.
Thank you, Minister. There is one comment that received from public interest, but before then, just a rider on this issue. I think to classify or categorize this misnomer as irregular is actually downgrading it. It's actually grossly irregular. And for you to suggest that had someone brought it to your attention, you would have recused yourself, you wouldn't have acted the way you did. I don't think.
Just to be, are you sure that it's a complaint that has been brought before me? I've not received it.
No, what I'm saying, yes, I only received feedback of it yesterday.
That I am
where
receiving
it said
I
that it will
have
be.
been involved in this discussion then on it. I'm not aware that.
And I
it's for
accept
me
you
to
may not be aware,
consider.
Minister. I was also only informed. I saw
know
it
the other,
in the
that's why
midday
I
yesterday.
stopped it. Okay, I'll have to be circumvent on it.
Okay, thank you. Actually, the conduct is inexcusable. And what was expected of you was actually very basic and elementary. That okay.
Can I interject you and ask, purely from this possibility that the minister just spoke about, just high level, that we leave it at that explanation and we leave it as the candidate has explained it? I'm sure that we can sit here and tear into it for longer, but because it has a potential then to end up at the minister's table, if it at all perhaps there is such a possibility. I don't think that taking it further than up to where we are may actually not compromise it one way or another when it has to go to somebody who has to adjudicate it. So
No, accepted, Minister.
Yeah.
But regrettably, we cannot unhear what you have heard. But I just wanted to bring to your attention.
That's why I had to make it on record that I was not aware.
Yes.
I've got my iPad, so I've been looking. I've not received it from it. Possibly it's coming with a fiscal memo that is coming through.
Thank you.
So it was something that we were dealing with. We could have managed it differently, but I think let's take it in that way. By the way, the OEA is under you. No, it's okay.
Advocate Van Rensburg in the office of the NDPP. Yes.
Okay. I'll take you through the objection from public interest essay. This complaint was authored by the chairperson of that institution, Tebogo Gas. I hope I'm not butchering the surname.
I think it's Tebogo Class.
Class.
Yes.
Okay. The Gas.
Is it Gas?
It's Gas. It's KH.
In a document I saw.
Yes.
Class. Yes.
Yes.
Sorry.
And I'll go straight into the key issues that concerns that he raised as an objection for your appointment. Her failure to recuse herself in matters affecting her husband constituting a clear conflict of interest. The existence of serious allegations linking her spouse to factional battles within SAPS, creating severe perception risks. Her misuse of prosecutorial authority in pursuing a matter that was plainly a sub-HR/disciplinary issue. The premature and poorly prepared enrollment of the Matela Koko state capture prosecution, which collapsed at great financial and reputational cost, and broader performance deficits during her leadership of the investigating directorate. The NDPP plays a pivotal role in safeguarding public trust, prosecutorial independence, and constitutional integrity. In our considered view, the cumulative concerns outlined in the attached submission materially compromise Advocate Johnson's suitability for this critical appointment. We thank the panel for its important work and trust our submissions will assist in ensuring that South Africa is served by an NDPP of the highest integrity and competence.
I dealt with the issue of the conflict. I can't take it further than what I dealt with. With the Coco matter, I also dealt with that at length. With the alleged HR matter, which involves the head of crime intelligence and others. I'd like us to be mindful the matter is sub judice. It is a criminal matter currently in court. Safe to say that the charge sheet is a public document. It is not an HR matter, and it was not about him sitting on a panel. It is about allegations that happened before the interview, during and after, that compromised the entire process. It wasn't just in a specific part. Lots of things happened before, during, and after, but that's not the only charge. There are fraud charges as well. So even if one says the corruption matter fell away, there's still other charges that they must answer to. And I want to be clear, Minister and panel members, IDEC did not look for a case. I did say at the ad hoc committee, there was a Section 27 referral that was made. We had to look at where this matter fell. And this matter fell not because it was one matter. There are 6 matters that form a collective of activities of these matters that fell within the definition of our state capture matters. Hence, we took the matter. With regards to what whatever challenges my husband has at work, I'm not in his place of work. He must deal with his place of work. They must deal with him. In the same way that if I have challenges with colleagues in my workplace, the national director, as my immediate supervisor, must deal with me. It can never be expected of me to enter that fray. I have never, and I won't. And I would expect that my space of work be respected in the same manner. It's not for me to have entered it. And I have not dealt with any matters because my husband works at Crime Intelligence. He's been there since 2009. These matters came to us in November 2024 through a complainant, and that we didn't make secret, and that there are 6 different matters that we have dealt with. And the head of Crime Intelligence, as he is now, has been there since, I think, 2021 or 2022, Minister. Just to be clear, if what we do is look for vendettas, cases would have been dealt with a long time ago. Cases could have been made up. That's not the job. We got a referral. In fact, if you'll allow me, Minister, I actually commented the other day, I said, if we didn't get this referral, we wouldn't have had any matters in that space, because that is the truth. These are the matters we were dealt, and that is why we're dealing with it.
Thank you.
Thank you very much, Advocate Johnson. You'll be happy to know that we've come to the end of the interaction.
So you take the smiley one away? Because he also infected the prof, because at a stage the prof was smiling.
So the smile just went through.
And even when May was telling me about my could and should, she still smiled. No,
at least the panel is friendly. No, thank you very much, Advocate Johnson, for coming through and for availing yourself to be put through the process. It's a process that we know it's quite interrogating. I hope we didn't come across as interrogating, but having a conversation with you. So thank you very much that you made yourself available, and the process ends here. I wouldn't explain to you. You know the process. You are internal as well.
Yes.
How it's going to run from here.
I am aware.
And thank you very much.
And may I take the opportunity to thank you and the panelists. I wouldn't have expected any better, smiles or not. This is a rigorous process, and what the NPA needs is exactly as it was explained. Nothing is personal. So I'm glad you gave me the opportunity. I have to let you deliberate as you see fit, and I thank you.
Thank you very much, and have a lovely evening.
I will. Thank you.
Okay, that's it, members. Until tomorrow.